ಹಲೋ ಸರ್, ವಾಯ್ಸ್ ಮತ್ತೆ ವಿಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆಯಾ? ಹಲೋ, ಆದರ್ಶ್ ಹಂಗೆ
ಕ್ಲಿಯರ್ ಇದೆ ಸರ್.
Any adjournments?
Serial number 16. Request 2 weeks time.
Why? The person will learn it from somebody.
Serial number 28, Your Lordship. Seeking adjournment in the matter, Your Lordship.
Number
28.
Serial number 22, Your Lordship. Serial number 22. I want to file statement of objection. Statement of objections.
Someone is mentioning there serial number 22.
I am mentioning, Your Lordship. Serial number 22. I seek we have 1 week's time to file the statement of objection for the respondent, Your Lordship.
There is a pair. Petitioner counsel Tulsi Kumar. Kindly inform the other side, madam.
I will inform, Your Lordship. I will inform.
The matter week after next at the request of the learned counsel appearing for the respondent. Yes.
Much obliged.
Serial number 14, my lord. Matter is still in the Supreme Court. The matter upon is still not in, decided. My lord.
What is the issue in one hearing?
Regarding bailiffs, the tribunal has given order of favor. The right judgment in this case, as far as is pending in Supreme Court. The right judgment in this case, the tribunal order is pending before Supreme Court. This issue gets classification.
Then how the appeal is maintainable here?
In the last hearing,
No, we will not adjourn the matter. We'll see how the appeal is maintainable before this court. Yes. We are not at fault the matter. Yes. You are for the request of the learned counsel for the petition.
Serial number 26. May request 3 weeks time.
After vacations.
Serial number 28, Your Lordship.
Trade Thakur. Serial number?
In 28, Your Lordship. Requesting for 3 weeks time, Your Lordship.
What is this? Entry tax matter? Huh?
Yes, Your Lordship.
Why you are seeking time, madam?
Lordship, there is certain personal inconvenience.
3 weeks.
Please, Your Lordship.
My lord, serial number 22.
Why 3 weeks time, madam? In serial number 28, next week, list the matter by next week at the request of the learned counsel appearing for the petitioner.
Oblige, Your Lordship.
My lord, serial number 22.
22 is adjourned by week after next, sir.
Please, my lord, I could not hear what the other advocate was saying, so I had to make a mention. Oblige, my lord.
My lord, serial number 24, my lords. I'm appearing for respondent, my lords. I'll file my counter, my lord. Kindly have it on next week, my lords.
At the request of the learned counsel for the respondent in petition number 8 for 2021. Kindly inform the other side, madam.
Yes, my lords, please.
4 weeks time granted to do the needful. Fix. Fix.
Basis their own calculation. This idea that we find on Thursday.
Who is appearing for the other side? BC Avinash.
Your Lordships, I am appearing for the respondent, Your Lordships.
Yes. For production of documents.
Yes.
What of the document? Considering the time of hearing the main application.
This matter can be disposed of.
Ah.
If we placed on record the documents and all formalities have been.
Kindly use the mics. The other side is through virtual mode.
My lords, the additional documents, my lords, is for the purposes of showing that we have paid the entire amount of settlement.
The amount has been paid, your lordships.
Shall we close the matter?
Yeah, please, your lordships.
But we have page number of this IA. Number 10 and then page number 11. Page number 10, my lords, at the bottom, my lords. Amount to pay 1 crore 25 on or before February 28. The next one, 1 crore 16 on or before March 7th, my lords. My lords, we have the next page at page number 11. First payment was paid on 28th February, 1 crore 25. Second payment was paid on 2nd of March. There are two tables, my lords. The amount that was proposed by them and accepted by us, thanks, completely paid. Now the repetition can be disposed of.
Now what is the prior in the repetition?
Repetition, there are a couple of tables, my lords.
You file a memo to withdraw the writ petition. So, in view of the out of court settlement, this does not writ petition does not survive for consideration. You file a memo.
I understand, my lord. The only difficulty, my lord, is this: that the possession and the document, original documents are available with them. Their request to us was to mention direction from the court, my lord, insofar as
Settlement that you would have come to an agreement in that regard also to hand over the position in the domain. The original
That has been mentioned. That has been mentioned in your lordship, sir. Sorry to interrupt. That has been mentioned in this one, your lordship. Settlement.
It's already mentioned in withdraw it, sir.
Please, your lordship.
File it.
But my lord, I think they want to give us an undertaking. Within 15 days, they will return the possession and the documents. So one of the problems.
That if they have already agreed, then there is no necessity for us to go into all that. We cannot go on to the merits of the case. Yes, then how can we decide? If it's already decided between both of you, that will be implemented by them. No, then there may not be court order. Then if we want to pass a court order, we have to go on to the merits of the case and decide and then pass. In terms of the settlement, you file a memo, we'll dispose of the matter.
My lord, pass over the matter.
Yes, pass over. Pass over. No, what is the main matter? Heard accepting the caution. You are appearing for the government, huh? Huh? Let him come. Let him come. We'll at least we'll pass some order on this IA1.
Well, in item 9, I beg to appear for the petitioner.
The counsel for the revenue is seeking time, sir.
Well, they had to come back with instructions. Malad, we continue the interim order till the next date. That's my only request.
The matter week after next, as prayed with the learned counsel appearing for the revenue. Interim order is extended till the next date of hearing.
I am so very grateful. I'm so very grateful.
Where is Mr. Govindraj? Mr. Govind Raj. Govind Raj. None appears for the respondent. Pavan. Is the matter week after next? Granted earliest time extended to the next date of hearing. Okay. Extend ಆಗಿಲ್ವಾ?
Still comply the office of section 6.
The vacating stay
ಎಲ್ಲ extend ಆಗಿಲ್ಲ.
interim order is not granted.
And to extend ಆಗಿಲ್ಲ.
When it was granted, sir? 19/4/2021. By the time office objections shall be complied to list, there was a direction to list it on 16/6. After 16/6, it is not extended. Ah? Sorry, sir. Sorry, sir. It is not extended. It has come up before several occasions. It was not extended. Have you complied with office objections? But it's not extended. This IA 1 of 2021 does not survive for consideration. Extended. Where is the occasion for us to vacate the interim order? What was the interim order that was sought for?
Application 530, what happened, my lord? Respondent was a dispute for the service of the bank for function of misappropriation. Then that the interested dispute raised, my lord, that tribunal has order for reinstatement by input custody of that is only. And it is that, my lord,
File Kodi court officer.
bank file inspection.
This is by the Indian bank.
Yes, my lord.
Will not extend the interim order. So let him come. Not dispose the application also. Let it be there. Recall that interim order extended and none appears for the respondents. This is the matter week after next. Yes. Yes. Yes, sir. Yes, kindly argue the matter, sir.
This is with respect to 2 IAs. Find the yes. These two, this is a very peculiar case, started in 2007, and it has not reached conclusive adjudication so far. It's of the case, plus to certain other factors. Now, look, in isolation, I will not be able to argue on these 2 IAs. I'll briefly go through the facts of the case and then proceed with the legal aspects of my arguments and these IAs. 2008, Milord, after I received the notice under section 13(4) because the certificate act from the bank, now it is Canada Bank, earlier it was Syndicate Bank. When I received the notice, I went to ASA before the DRT in 2008, number as 57 of 2008. In that, day 1, first day, first show, I was yelling before the court, there is nothing new. 2 points. There is no dispute that I had taken financial assistance from the bank for exporting credit accounts. Second, there was no dispute. I had prepared those, manufactured those and shift it across to the foreign buyer. So I have neither diverted the funds nor created a fraud, nor had done anything wrong. Now, in this particular case, there are 4 dimensions. Normally, it is the borrower, the guarantor, the bank, the mortgage property. That is 3: guarantor, borrower, mortgage property, and the bank. In this one, there is a 4th dimension: the Export Credit Guarantee Corporation of India. Now, that's a government undertaking. So, briefly stating about the ECGC, during those.
What is challenged herein, sir? What is challenged herein?
The challenge is the 25% deposit. I'll come to that, my lord. But
Kindly come to that, sir. Kindly come to that. It is
Because
on a narrow compass. Whether 25% pre-deposit is necessary or not, that is the only issue involved here.
please, my lord. Okay, I'll forgo the second part. Now, please, my lord, I'll demonstrate before this honorable court. Lordship, kindly turn to. Lordship, kindly turn to page number 50 of the petition. Annexure C. My lord. Page number 50, my lord, is an affidavit. Affidavit of the petitioner.
Yes, sir.
We filed it in petition number 33975 of 2018. As per the instructions of the this honorable division bench of this honorable High Court, the respondent filed the statement of the receipts from ECGC in respect of my account. So, in response to that, we have filed this affidavit.
Yes, sir.
Now, my lord, initial demand notice was for 5 crores 72 lakhs 33,033. This was the initial demanded amount.
Yes.
Bank had deposited 5 lakhs. Oh, sorry, petitioner had deposited 5 lakhs. That is, I had deposited 5 lakhs on 29/3/2008 as per the orders of the court, DRT, so that the matter is heard properly. And for statement of account, I asked for statement of account because at that point of time only, they received more than 3 crores of the 5 crores which they had demanded from ECGC. So, this 5 lakhs I deposited. Hereafter, the memo of R1 bank shows that the total insurance claims received by the bank, this has been also submitted in this petition, Lord, at page number 16. And the last page is totaled up. So, here, they have themselves accepted, they have themselves given this, that they have received 5 crores, 5 lakhs, 24,758 in respect of my account. There is no dispute in that. 5 lakhs, there is no dispute. 5 crores, 5 lakhs, there is no dispute that they have received it. Then, out of that, remaining is 62 lakhs, 8,275. Now, Lord, 25 lakhs were deposited by the bank. I have given the DDs also, copies of the DDs, etc. in the previous petition 33975, which clearly show that 25 lakhs has been received by the bank. This was on 18/9/2018. This also the bank has not disputed that they have received it. Then, as per the letter dated 4/3/2011, my lord, of the bank, they had asked for a compromise. They had agreed for a compromise of 1 crore 30 lakhs, and to show the good intention, they asked us to deposit 20 lakhs. That 20 lakhs was deposited on 7/3/2011. Now, my lord, the balance due is only 17 lakhs 8,275. Now, whenever I exported a bill, 10% of the amount which was paid by the buyer was retained by the bank as a deposit.
Where is the order passed in this writ petition 33975 of
Please,
2018?
Please,
Where is the order, sir?
order. Page 34, yeah. It's there, my lord.
No, that is 34511 London Senior.
Yes.
Sir.
34511.
Here it is 33975 of 2000.
33975. Division bench.
Page 41.
Here. 3397, page number 41 here. So here, in the order sheet, you will find that the bank was asked to give the details of the amounts deposited by ECTC in respect of my account. And in as a consequence, they filed the statement given at page number 60. So on that basis, I said that there is no dispute. They have got 5 crores, 5,24,758 from ECTC towards my account. So the balance left was 62 lakhs, 8,275. Next page. 25 lakhs was paid. This also they have not disputed. I have put the draft copies and everything. Now 20 lakhs was for the compromise that was deposited. Remaining was 1 crore 10 lakhs. That could not be deposited in time. The bank on a technical ground completely rejected the compromise offer. So again, we were back to square one in litigation. So the balance due was 17 lakhs. Now, whenever we exported any item, any garments or cargo or exports, they used to keep 10% in fixed deposit towards margin. That is, ECGC was carrying 90%. 10% margin was kept by them. So these 10% margins amounted to 22 lakhs over a period of time. That 22 lakhs also, if it is 17 lakhs is due, plus 22 lakhs, it is minus 4 lakhs 91,725. Now, my lord, if your lordship will kindly go through it, as soon as the ASA was filed, they had already received about 3.5 crores as per the demand notice. Of the 1 crore and odd, within the period of 1 or 2 years, more than 2.5 crores was paid by way of cash, by way of deposits, by way of other things. So the interest factor, if any left over, does not exist. So all that could have been adjusted within this. Still the bank could have owed me something. Now, main point which we have to consider, that being the case, there is no due payable by me. As per their statements, nothing has been disputed. The learned DRT made a mistake of not even considering the undisputed factors. And passed an order, if mandatorily 25% is as per the Act. So mandatorily you deposit 25% of 5 crores, which I'm not liable at all. That was the bone of contention, because of which we have been shuttling between the Honorable High Court and the DRT. Now, my lord, be that as it may for a moment, I come to the latest judgment of the Honorable Supreme Court. It has been submitted, my lord. Kotak Mahindra Bank case. Kotak Mahindra Bank case. In that, my lord, the full bench, Honorable Mr. Justice S.A. Bombay, CJI, Honorable Mr. Justice A.S. Bopanna, and Honorable Mr. Justice V. Subramanian. This is the latest, and it has been beautifully brought out. How?
What is a citation?
Submission, my lord. I couple
Citation.
I'm coming to that part only.
Where is that, sir? Where is that
I'm coming to that.
court officer? Where is the judgment copy?
The first judgment is submitted by the court. Now I pray Your Worship may kindly go to page, the next second page, para 4. Of Your Worship, permitted. This is the core and crux of the matter, similar to mine, and the ratio decision will show clearly that I am not lying. That is what I wish to submit. Now, para 4 says the brief facts leading to the present proceedings is that respondent number 3, namely, Hinson River Mills Limited, had availed financial assistance from the respondent number 6, IFCL Limited. The respondent number 1 and 2 had offered their personal guarantee in respect of the said financial assistance. The respondent numbers 1 to 3 had defaulted in repayment of the dues, and the account, having been classified as non-performing asset, was thereafter auctioned by the respondent number 6, IFCL Limited, wherein the appellant herein was the successful bidder, and accordingly the unpaid debt and non-performing asset was assigned in their favor. The assignment as made was assailed by the respondent number 1 to 3 before the High Court in WP Civil 14999 of 2006, which came to be dismissed, and the SLP number C 35004 of 2011 filed was taken note by this court, and in the settlement which was entered into between the parties was recorded and disposed of. As per the settlement, the respondent number 1 to 3 had agreed to repay the sum of 145 crores with 3% per annum, subject to the same being repaid on or before 31/7/2012. The respondent number 1 to 3 are stated to have not adhered to the terms of settlement, and the repayment was not made. The appellant bank therefore instituted recovery proceedings by filing an application before the Debt Recovery Tribunal, New Delhi, in OA 281 of 2015. In the said proceedings, the appellant bank claimed that the respondent 1 to 3 could be liable to pay the entire outstanding, since the benefit of settlement, wherein the outstanding amount was frozen, had not been availed within the time frame. Accordingly, the sum of rupees 572 crores 18,77,112, which was due as on 31/12/2014, along with interest and other charges, was claimed before the DRT. When this was the position during the pendency of OA 281 of 2015 before the DRT, the respondent number 7, National Highways Authority of India, NHAI for short, acquired a portion of the mortgage property belonging to the respondent number 3 and deposited the compensation amount of 62 crores 31,87,312. And before the DRT, the compensation was thereafter enhanced by the district magistrate, Ghaziabad, and a further sum of 72 crores 96 lakhs 12,827 was deposited. Thus, in all, a sum of 152 crores 81 lakhs 7,159 was the compensation amount which was deposited on behalf of respondent number 3 relating to the mortgage property, which was credited to the account of respondent number 3. Number 3. With these developments in the background, the DRT had proceeded to consider the claim application and ultimately ordered issue of recovery certificate through the order dated 15/3/18. Through the said order, as against the claim, DRT had limited the decretal amount to 145 crores with future interest at 9% per annum till the realization on reducing balance. It was further ordered therein that the amount would be payable after taking into consideration the amount of 152 crores 81 lakhs 7,159 during the pendency of the proceedings, paid during the pendency of the proceedings. The appellant bank as well as the respondent number 1 to 3 claiming to be the aggrieved by the order passed by DRT have preferred the appeals before DRT. Now, after all this happened, finally the Supreme Court, the full bench, came to the conclusion that at para 14, para 14 of page number 2021, see 1045, sorry. 2021 page. Therefore, para 14.
Yes, sir.
Para 14. Below. Therefore, in the facts and circumstances arising herein, when further amount is due and payable in discharge of the decree recovery certificate issued by DRT in favor of the appellant bank, the High Court does not have the power to waive the pre-deposit in its entirety.
No.
Nor can it.
Para 14.
Yeah.
How it begins?
Below.
How it begins? Para 14. In that regard, the High Court has concluded as hereunder.
Please, below. So my point here is.
No, read it. Which para you are reading? Kindly read it.
Therefore, in para 14 minutes, therefore, in the facts and circumstances.
Where is therefore here?
Page number 1045. Okay, this AIR says therefore, whatever. AIR is authentic. We have to accept that.
How the paragraph begins, sir?
That's what, my lord. Therefore, in the facts and circumstances arising herein, that is where it starts. Of yours,
yes.
When further amount is due and payable in discharge of the decree recovery certificate issued by DRT in favor of the appellant bank, the High Court does not have the power to waive. That's what they say, Lord, is suppose 100 rupees is due and the recovery takes place, let us say after 1 year, of 101 rupees. Then 1p is not due. The interest on that 100 rupees for 1 year will also be added, and the difference amount, that is 100, the difference amount of, let us say 125 with interest, 125 minus 101 will be the amount due and payable, legally enforceable debt. Of that amount, 25%. That is what the Supreme Court has come. The ratio difference is very clear. So, in my case, nothing is payable, it is minus. Interest factor is not there. There is no other claim whatsoever. From day one, that has been my stand. Even today, it is the same. So, when nothing is due, I tried to argue before the DRT. I asked for half an hour's time to argue the whole matter in toto. The Honorable Presiding Officer rejected my request for half an hour and said the council wants a long time to argue and just passed an order, 25% mandate. That is why we are before this Honorable Court now. Look, as per the ratio of this case, of the full bench, point is, if the entire amount has been received back, see, if the difference amount has been taken into consideration for the purposes of fixing 25%.
Read that paragraph at least. Let us understand what is there. Therefore, in the facts and
circumstances. Okay, then it will come in para 16 of AIR.
You are reading para 17. Therefore, in the facts and circumstances.
Okay, further amount is due and payable in discharge of the decree of the recovery certificate issued by DRT in favor of the appellant bank. The High Court does not have the power to waive the pre-deposit in its entirety if there is any due further than what has been received. Nor can it exercise discretion.
No. In its entirety, that's all. Then don't add the words while reading.
No, that I am talking about.
No, don't add your words to the while reading it, sir.
Nor can it exercise discretion, which is against the mandatory requirement of the statute provision as contained in section 21, which is exempted above. In all cases, 50% of the total amount.
Kindly read it once again, sir. Nor can it exercise discretion, which is against the mandatory requirement of the statutory provision
as contained in section 21. Now, this portion, if there is no dispute, 25% is mandatory as per the law. That I am not disputing.
Yes.
What I am saying is 25% of what? That is the point which this judgment clarifies. That is what I was trying to come to. Now, here it says, Lord, the Honorable Supreme Court has said in para 16 that having arrived at above conclusion, the issue is also with regard to the extent to which pre-deposit is to be ordered in the instant case. Though the learned senior advocate on either side have indicated different figures as the actual debt due as on today, we do not propose to enter into the aspect of that matter, since the actual amount due is a matter which would be taken note by the DRAT while considering the appeal on merits and at that point of recovery, if any, in the execution proceeding. However, for the present, we would take note of the amount as indicated in the order dated 27/2/2019 passed by the DRAT. Hence, for the purpose of determining the pre-deposit, the decretal amount due is taken at rupees 68 crores 18 lakhs 92,841 and not 152 crores. They have reduced that. Whatever has been received has to be reduced. So this 68 lakhs is of interest and other assets. They have taken that as the basis for calculation of 25%. And the Honorable Supreme Court said 25% of this is payable before the appeal can be heard. So that is what I wanted to come to. When my due is minus and it is not disputed anywhere, I have filed it by way of an affidavit. I have given clarification.
Let us see the DRT order. Let us see the DRT order.
DRT. We are coming appeal subject to the consequent to the DRAT order.
No, against which order you have filed an appeal before the DRAT?
That asking us to pay 25% of 5 crores.
Against which order you have filed an appeal before the DRAT? Let us read that order.
Here it is.
Against which order the appeal is preferred now? That order.
Page 39, my lord. Yes.
That is DRT
No,
order.
that is only for time.
Sir, against DRT order, you have preferred an appeal before the DRAT. We want to see the DRT order.
Original order ASA. ASA page number 39, my lord. On the statement of objection.
Yes, sir.
Page number 39.
So what is the decree there? What is the order?
Dismissed. My contentions have been dismissed.
Then what remains?
That 5 crores
Then
72
what
lakhs.
would be the inference? What would be the inference? If your contentions are dismissed, what is the liability
That
fixed?
means I am liable for 5 crores 72 lakhs.
Against that order, you have to you approach the DRAT. Against that quantum, you are liable to pay the pre-deposit. That's clear.
That is the original
You
agreement.
cannot go into the what is the quantum now? You are liable to pay. That is left to the realm of it is coming within the jurisdiction of the DRAT to consider it and to give a decision. As observed by the honorable.
There's only one point here, which I wish to bring to your kind notice. No, kindly, page number 28, my lord, of the petition.
Now, in page number 39, this is the order of the DRT. No, let us go step by step. So, in page 39, in the order of the DRT, you have that is your appeal for the DRT.
No, that is against the Secrecy Act. I find that appeal.
Correct, sir. That is your appeal before the DRT. That has been dismissed.
DRT had dismissed, against which we came in petition to the High Court. 34511.
Now, in this DRT, we'll go step by step. In this DRT, what is the observation made by the DRT? What is the total liability?
Total liability is not mentioned.
Claiming rupees 5 crore 72 lakh 33,000 as due from the appellants. That was your gross. The grievance was that the bank had claimed 5 crore 72 33,033 as due from the appellants.
Yes.
That was rejected.
That was rejected.
So against this order, sir, against this order, you filed the writ petition.
Yes.
Where is
No,
that writ
that
petition?
is page number, it lasted for a long time. Initially, the stay was granted. Once again, stay was granted. Thereafter, this was disposed of on 14th February 2017. Lord, kindly turn to page number 28.
Date of the statement of objections or the writ petition? Writ petition, huh?
Writ petition. Writ petition number 34511 of 2009 GMDRT. In this segment, starting at page number 28, you may kindly turn over to page number 3, my lords. This honorable court would have adjudicated it on the spot at that point of time had it not been for para 3. It is no doubt true that the rule had been issued and this petition was pending consideration for this court. However, during the pendency of this petition, honorable full bench of this court, in the case of Deepak Apparels Limited and others versus City Union Bank Limited and others, reported in ILR 2016 Karnataka 1805, has held that against the order passed by DRT in appeal under section 17 of the Surface Act, the remedy for the party aggrieved is to file an appeal under section 18 of the Surface Act. Learned counsel for the petitioners would no doubt contend that in the instant case it is to be considered as an exception, as has been indicated in the said judgment, and the writ petition is to be entertained by this court. Now, my lord, the next paragraph, paragraph 5.
So you were relegated to avail the appeal remedy.
Yes, my lord. I'm going further.
Yes.
Paragraph 5, my lord, the last portion. In the instant case, the contention of the petitioners is that with regard to the transaction relating to the export of garments for which financial assistance was obtained from the first respondent bank, it was also covered under the insurance through ECGC, for short. Although such contention is urged by the learned counsel for the petitioners, the matter ultimately to be decided is to whether, despite any amount having been reimbursed by ECGC to the first respondent, and if the same is credited to the loan account of the petitioners, the first respondent can still claim such amount, and in the circumstances, whether the account of the petitioners could be treated as NPA, and therefore provisions of the STC Act can be invoked, was the point of direction lot for DRT. Go into it. It was not gone into even by DRT. Then, further, I knew, my lord, DRT would throw my appeal out on invitation. I requested his lordship kindly say something about limitation, my lord, because it will be thrown out on limitation. Para 7, my lord, they have said, his lordship has said very clearly. Hence, for the said reasons, I find that even in the position.
We understood it, sir. Then what happened?
We went to DRT. It was dismissed on limitation again. Despite the direction of this honorable court.
Where is the order? Where is the order? Next order passed.
That's what DRT order. Dismissing and on limitation.
IA 487 of
487, Lord. The order on 487.
So against that order, you approach this court in writ petition number 33975 of 2018.
33975. He approached.
Yes.
Then this honorable court said, nothing doing. It is within limitation. You may entertain the case and proceed ahead. Then, when I tried to argue on the pre-deposit point, I was not at the time, and the order was passed, paying 25% of 5 crores.
Now, where is the impugned order annexure Ella?
Last. Page number 119 and 120, my lord. In the event of failure in any part of the amount, the appeal stands dismissed automatically without any reference to this by this tribunal. IA is disposed of and closed. On receiving pre-deposit amount, appellants will be entitled for protection from recovery exercise and parties will maintain status quo. That is only subject to payment of the 25%. Our bone of contention is 25% of what? Where does the DRT state? But in this particular petition, Lord, His Lordship had I wanted to just bring it to the notice. Actually,
It's made very clear, sir. 25% of notice amount, that is rupees 1.43 crores.
exactly, Virat. Exactly.
Ah.
My point is, the notice amount itself is not payable.
That we have.
That is the case.
That has to be
That-
considered by the DRAT. Not
I've shown you, Virat, the affidavit.
yes. The
Clear
affidavit
statement of
you may
account.
You may file some affidavit before the court.
But that was
But they
heard by
will
DRAT, so we are before your lordship.
If the affidavit was accepted, whether any finding was given that your liability is so and so.
No, the order is not a speaking order. DRAT order is not a speaking order.
Yes, sir, we will consider. Yes, sir. Then the senior counsel.
A person aggrieved by any order made by the state security tribunal under section 17 may refer and appeal along with such fee as may be prescribed to the appellate tribunal within 30 days with the date of receipt of the order of that security tribunal. Provided that the reference fee may be prescribed for filing an appeal by the borrower or by the person other than the borrower. This is important. Provided that further no appeal shall be entertained unless the borrower has deposited with the appellate 50% of the amount of the debt due from him as claimed by the secured creditor or determined by the debt recovery tribunal, whichever is less. The next provision this is provided also the appellate tribunal may, for the reasons to be recorded in writing, reduce the amount to not less than 25% of the debt referred in the second provision. So it is the debt referred for. In this case, maximum of 50%, minimum of 25%. So the discretion with the DRAT is between 50 and 25%. That full discretion has been given. In fact, for giving 25%, the any person is agreed with the appellant. The reasons are not recorded. In fact, with reasons or without reasons, the DRAT has no discretion to reduce it below 25%. The amount is what is 25% of the debt due. As pointed out, debt due was 5 crores and 83 lakhs in all. The page 40. I should notice that. Again, which the NHL are due. The amount is 5 crores 72 lakhs 33,000 as on 2009. Now we are in 2022. Now the amount due is 23 crores. We are not going into that because that is not the issue. The debt due is taken as per the notice. Now 5 crores. Therefore, the DRP says 1 crore 30 lakhs. Rashmi Technical Art 2, page 40. Para 2 last 3 lines.
Yes.
Whether the respondent bank does not publish the statement of account and has charged higher income interest, the unit 1, claiming 5 crore 72 has due from the appellant. The appellant has paid 25 lakhs as the initial deposit, which is not adjusted by the respondent bank. Then after these are the contentions. Accordingly, this application came dismissed on para 4, page 43. On verification of trading proposed by the appellate as well as the respondent bank in the particular case and also the documents produced by both the parties, there are no material irregularities that have been committed by the respondent bank while initiating proceedings under the Surface Act. Further, the appellants are unable to establish their case as stated by them in appeal. So, therefore, the date of the order is 2009.
Where is the notice, sir? In paragraph 2, there is a reference. This is an appeal preferred by appellant seeking the relief of setting aside the notice dated 19. Notice dated 19/11/2007 issued under section 13(2) and notice dated 8/2/2008 issued under section 13(4).
That notice has not been placed before your lordship.
That is in the original petition, my lord, 34511.
In that notice, we have paid 5 crores 72 lakhs. Ultimately, the Supreme Court judgment rely upon also that is Court of Mahindra. They say that 25% is the minimum amount, no further discretion can be given. And in the particular of fact of those circumstances, court fixed the amount, last paragraph, which is not to be relied upon. That page number paragraph 17. Page number 7, paragraph 17. Don't repeat it, no, that is where, therefore, the fact is supposed to be when further amount is due and payable to discharge of the degree of recovery certificate issued by the DRT in favor of the amendment, High Court does not have the power to waive the free deposit in its entirety, nor can it exercise its discretion, which is again the mandatory requirement of a statutory provision, which is 25%. As contained in section 21, which is expected above, in all cases, 50% of the declared amount net due is to be deposited. But in appropriate cases, for the reasons to be recorded by the deposit of at least 25% of the debt due would be permissible, but not entire waiver. Therefore, the waiver of free deposit to the entire extent would be against the statutory provision and therefore not sustainable in law. The order of the High Court is therefore liable to be exercised. Then, what was written paragraph 21? I've already noted total waiver would be against statutory provision has not been last 5 lines from below. We deem it appropriate as a peculiar facts and circumstances. This case may permit 69 crores. So therefore, under Article 142, the peculiar facts and circumstances, they passed an order, taken to be deposit 68 crores. 55%. So therefore, according to us, 2009 it is 5 crores. As on today, 2022 it is 23 crores. Don't go by 23 crores. Go by what was in 2009 5 crores. Of that 1 crore 30 is what is 75 and 2 installments have been given.
My only point is, why 5 crores in that case? Why not 25 crores? Because it is not payable. It is not a debt legally recoverable. And we are fighting from day one that 5 crores 72 lakhs is not payable. Therefore, the DRT was also thinking twice about it before writing 25 crores. And one more instance I would like to say, when the matter came up for arguments, just about 6 months before that, they had filed a statement of account stating that 12 crores are due. And just 1 day before the arguments, he filed another statement, the learned counsel for the respondent bank, that 25 crores are due. Even his lordship at DRT commented 12 crores was what you had given as on that date last. Now you are saying 25 crores in 1 year. Are you charging 100 and odd % interest? How do you justify 25 crores? He was unable to answer. The bank was unable to answer. So all sorts of hanky-panky has gone into this calculation, Lord. We have paid, nothing is due. That is our case. And it has to be only on the debt due as per this judgment of the full bench. It is not due, then there is a question of 25%. 25% of 0 is also 0. So my point is that when nothing is payable, 25%, okay, mandatorily 25% I deposit. 25% of 0 is 0 deposit. I have to deposit 0 rupees. That is my case in the entirety. And why has it taken so many years? Unfortunately, it would have been finished by the honorable single bench. But unfortunately, the Deepak Spinner's case came and we were relegated back to DRT. Otherwise, it would have been decided here. Unfortunate for me, Deepak Spinner's full bench judgment came at that point of time when it was almost posted for judgments and final year. So, that being the case, and nowhere have they disputed that they've got all this money.
No, whether even on this pre-deposit, the matter was considered by this court?
Yes, madam. Page, my page is 49 is shown, internal page, judgment of HSC, page 41 and 49, paragraph 12. While condemning the delay, page 49, page 49, to consider the matter to pre-deposit and issue and other issues thereof. Other matter of merit. So therefore, with regard to pre-deposit, page 49.
Yes, sir, we got it.
Pre-deposit was considered.
No, we got it. We are putting this question. This reason that at page 119, there is an observation by the tribunal that on 10/1/2020,
Please, madam.
Tribunal has directed the appellants to make a pre-deposit of rupees 2.86 crores with the registrar of this tribunal within a period of 4 weeks from the date of the order. In view of the observations made by Honorable High Court of Karnataka, now I hereby extend maximum benefit of waiver. So in which case this direction
For this case, okay. Same matter.
Which I just pointed out.
waiver?
Same matter.
Election H.
First, he had given an order for 50%. That was struck down by this court.
Not
He
control.
gave 25%.
Huh?
First, the DRT had ordered payment of 50%. Later on, we were before this court again. The honorable division bench said, no, it has to be a reason and speaking order. And
Where is that order?
Election R5
Annexure?
R5 of my statement of opposition.
That is different order.
That's a different order. If the expedition was filed, that was 50% get directed to the
Yeah.
So therefore, one of the court said, he does not make any amount.
they had not fixed. The honorable court had not fixed. But to avoid giving a speaking order, he reduced it to 25%.
Annexure R
R5.
R5.
Page number
R-
60.
Annexure R5. This is the order passed by the Debt Recovery Appellate Tribunal.
This last but one paragraph forward. I hereby direct applicant to make a free deposit of 50% of the demand notice at 2.86 crores with the registrar. The Lordship got it, just about last but one paragraph. Last 3 sentences.
Yes.
I hereby direct.
So against this, another writ petition must file.
Which I just read the Lordship, where at page number.
What is page 61? Writ petition 2495. 2495.
20.
Page 106, that is order dated 1st October 2020.
So what is this order dated 6th February 2020?
The 6th February was the election, R5 was challenged. R5 was
Yes,
challenged.
that is what we are observing.
R5 was challenged in election. WP number 2495 of 2020. Page 41, WP number 33975, what was thought to be challenged is number. The order dated 27 July 2018 order.
Now, this is the final order, that 2495 of 2020, wherein this court has directed to reconsider the 50% of the pre-deposit amount directed by the DRAT.
Yes, page
Ah,
para 13, last page, page 13. Thus, the provision of the order, it is evident that DRT has not other any reason for directing the petitioner hearing to make pre-deposit of 50% amount in the demand notice and in cryptic and careless manner has been recorded. The conclusion directs the petitioner to deposit 15% of all demand amount. So this is what initial the improved order suppose through twice a non-application of mine and cannot be sustained in the IM form. The improved order is thereby forced.
so pursuant to this, the impugned order is now passed. Now it is 25%.
25% beyond which the statute, the appellate tribunal or
Even the High Court has no power.
It is less than 25. So therefore, between 15 to 25, they should record reason. Less than 25, it's a statutory requirement.
Because, as I had already submitted, 25% of what is the question in this case? Mandatory 25%.
Sir, in all cases, the defaulters, borrowers comes before the court with the contention that there is no due from my side.
No,
Yes, but in all cases, in most of the cases,
Payments have not.
that would be the defense taken by the borrower. have paid all the amount.
Now there is one more
Can we sit in
point of law I
judgment?
wish to.
Can we sit in judgment? What is the amount liable to be paid by you now? We have to go by the notice.
Now, my lord, I'll like to submit only one point of law,
Yes, sir.
which has mostly been overlooked in most of the times.
Ah.
As per the insurance jurisprudence, an insurance company, when it pays a claim, doctrine of subrogation applied, and the insurance company steps into the shoes of the insured. So here, bank loses its locus standi to file a suit against me under the doctrine of subrogation of rights. So only ECGC could have filed, if at all, and no insurance company can file a suit for having paid a claim. Otherwise, the very purpose of insurance is defeated. So the point here is, does the bank have the right and locus standi to file a suit against me for recovery? That is the point of law, which has to be answered by this honorable court, because this is the best point of time to answer this particular.
Sorry, sir, we are not going to that question. That is not before us.
They have no locus standi to file the suit.
We are not going to that question. That's not before us. Now we are focusing only on the
Only
pre-deposit
25%.
amount.
25% of what is the only question?
Yes, we have understood it.
My lord, at the cost of repetition, my
No power to this. We are 25%. We are 25%. We have no power, sir.
one small submission, Lordship. The Lordship may kindly see page 117 of the petition. The same order which my learned senior colleague had read in part. I want the full thing to be read. The impugned order suffers from page 117, my lord. Of the petition, Lord.
117.
117.
Yes.
The impugned order suffers from the vice of non-application of mind and cannot be sustained in the eye of law. The impugned order is therefore quashed. The appellate tribunal is directed to.
Yes.
The appellate tribunal is directed to decide the application filed by the petitioners afresh by a speaking order in the light of rival submissions made by the learned counsel for parties by a speaking order within a period of 3 weeks from the date of receipt of the certified copy of this order, of the order passed today. It was not even heard, let alone considered. That's all it is.
Yes. Who is Mamtaz Begum? Guarantee. 50% of the amount of the debt due from him as claimed by the secured creditors or determined by the debts recovery tribunal, whichever is less. Now we have to go by the determination made by the debts recovery tribunal. The determination made means the tribunal has dismissed their appeal. Now your notice stands. Yes. So there is no difference between the debt recovery tribunal order and the notice.
And one other thing, our condition was 25 crores. Court says that your notice is 5 crores 22 lakh.
No, where you have said 25 crores.
37 will be kindly sent for a moment. Page 37. Page 37, para 3.
Yes.
Last 3 lines in para 3. Even then, the issued notice of demand was under 32 was sufficient. 1911 for recovery of some of 5 crores 72 lakh 33 so and so. Per contra bank, should be kindly identify all the sufficient para 39 para 7. Page 39 para 7. So far as the merit of the case is concerned, this substantially okay, during the course of the argument, it was answered that asked the bank has already filed owing on the under the RBI for recovery of 25 crores from that. All the agreements can be ventilated after the parties are advised to do so. Appellant never offered or deposit any amount whatsoever during litigation. So therefore, whatever the amount due is entirely different. Here the question is the notice amount is with regard to notice amount is 5 crores. 5 crores of 25% of 5 crores is paid.
Paid by the creditors, secured creditors, or determined by the debts recovery tribunal, whichever is less.
Then the less amount is 5 crores now. So recording of reason would be if the amount is between 30%, 50% and 25%, the reason to be recorded. Any amount, the lowest statutory requirement is 25%. So therefore, even though the reasons have been given, it is a bare minimum with the DRAT also does not have jurisdiction to even if it record reason to reduce below than 25%. But the lowest amount of 5 crores has been taken, not 25 crores as they say, or 12 crores or what you set amount. Let them deposit. In fact, let the amount be deposited. Let the main matter be heard. Whatever condition of merit within the time period it may be decided. We have objection. Whatever the amount should be decided within 1 month, 2 months, 3 months. Yes, we will cooperate. Let them comply with the statutory requirement. Matter be decided in the time bound manner.
I had made one small prayer before the DRAT. I said, Lord, there is a provision in law that if I state anything false or wrong, you have the power to penalize me. I am the borrower, I am saying nothing is due and payable. You please proceed, allowing me not to pay the pre-deposit, adjudicate the matter, and if anything, even 1 rupee is found to be payable by me, you can penalize me. That was also not objected to by the respondent. DRAT. And that was also just overlooked by the Honorable Chairperson. There is a provision for penalty in the event of anything payable. When I am saying nothing is payable, if there is anything payable, I am liable to be punished for it. Why not that? Let me prove nothing is payable. And I have already proved it anyway. I'll prove it formally before you, Your Honor. And if you find that it is false, nowhere have they objected to all the statements that I have made. If it is found to be false, you can always be like, that was also not taken up.
No, that discretion is not vested with the tribunal. The maximum relief that could be given is only to waive it up to 25. The minimum amount that could be pre-deposited is only 25%. That is the maximum relief that could be granted by the
Correct, my
tribunal.
lord.
No other discretionary power is vested with the tribunal.
That is not fair. In a peculiar case like mine, it's not fair. When I'm not due to pay anything,
No, in each and every
when I'm
case,
forced to pay.
each and every case, that would be the defense taken, sir. How can we decide that issue here?
No, my lord,
What is the total?
law has an exception.
Yes.
Now, every case, mandatory required 25%. There is an exception when nothing is payable.
No,
That is my point.
in the judgment before the Honorable Apex Court, they have asked the borrower to, the appellant daring to pay 25% of some amount.
Some amount.
What is that some amount?
That is
65 lakhs and odd.
That is-
What is that amount?
that is legally recoverable after
No, no,
receipt of the,
from where they got it?
that is whatever amount was paid,
No,
As
from where
compensation.
they got it? From where they got it?
the first demand notice.
First demand.
First demand notice.
So it almost it relates back to the
Yes, my
demand
lord.
notice.
But after the first demand notice,
So it
the-
relates back to the demand notice.
the honorable court.
So here the demand notice 5 crores and odd.
Correct, my lord.
Yes, sir.
My point was, the
Yes.
honorable Supreme Court took cognizance of that,
Yes.
whatever was paid.
Yes.
The first demand notice 152 crores. The Supreme Court took cognizance of 68 crores. Why? They took cognizance of the.
Because of the first notice.
Of the first notice, after the first
Also the
notice.
first notice will go.
The first notice, my lord, was 152 crores. The Supreme Court said 68 crores for the purpose of 25%.
Correct, sir. How did it arrive at?
That's what, the amounts reimbursed to the bank,
How do that is correlated
this is
to?
what the reimbursements they got as compensation. That is what the judgment is all about. The ratio is that. If amount is received, it has to be reduced. That is the ratio. And it's easiest case.
Sir, the decretal amount is taken. Kindly come to para 19. Hence, for the purpose of determining the pre-deposit, the decretal amount due is taken at rupees 68 crores. So that is the decretal amount. Not you are adjusting all that amount and all. It is a decretal amount which has to be taken. Sorry, sir, we have given you the patience hearing. Viewed from any angle, we cannot interfere with the order passed by the DRT. Maximum is 25%, not more than that. Consent dismissed. Yes, next matter. All the pending applications stand disposed of accordingly.
Next one.
Yes, next.
811. For amendment of.
What is this amendment application file? Yes, Mr. Raju. What is this application? Amendment application? Yes, yes. All the pending applications stand disposed of accordingly. Yes. Yes, next matter.
Memo file matter 7 for dismissal. Issue the senior counsel. This is 7 also right to withdraw there.
I am appearing for the petitioner in this case, Lord.
Yes, sir.
I am appearing for the petitioner in this case.
Yes, sir.
So last occasion, Lord, two occasion, your Lordship not raised the two questions regarding the maintainability of the writ petition before the division bench is one thing. Second, maintainability of the complaint before the special court is another thing. That the two issues not so far. Judgment of this division judgment, reported judgment plot in WP 107303 of 2019.
107.
7303 of 2019. This is the reported judgment passed by the Honorable Court by Division Magistrate Justice Arvind Kumar and Justice Perunki. I am Lord, one more judgment.
Party's name, sir.
Parties Pundali.
Judgment. What is the reported judgment citation?
Report citation, Lord. Batch up adu.
Court officer. This correct monitor sir.
25th June 2019 ali. So judgment was delivered by this honorable court, Lord.
Yes, sir. What is that you want to emphasize now from that judgment?
Against him, Lord, conviction, Lord, writ petition is maintainable before this honorable court. Otherly, conviction mele. See, because the special court has given that conviction.
Which paragraph you want to read? Have you furnished the copies to the court?
Actually, I am not able to, Lord, because I am appearing through the video conference. Lord,
How many times the matter is listed, sir?
So because 24th, physically I will come and argue this case before you.
Sorry, sir, we will not adjourn this. How many times the matter is adjourned?
Sorry.
At your request, the matter is listed today.
Judgment
Yes, we will not adjourn the matter. Kindly place it.
Please.
Pass over 2:30.
Please.
2:30, sir. We will not adjourn the matter.
Please.
How it is maintainable? Yes, if the identical issue is already pending before the Honorable Apex Court, how it is maintainable regarding the classification? No, classification issue you cannot take up under 35G. Yes. Let us put it is filed under which provision? This appeal. Sir, this appeal is filed under which provision? 35? Regarding the classification. How this is maintainable before this court? File Kudi Court Office. This is the appeal by the revenue. Yes.
In the site of the JSW sheets. It's pertaining to the metro matter, the Delhi metro. This is for the public matter from the public fund. But matter in this case, matter between the commercial space and the funding is being done by the commercial.
Yes.
The issue here is it's not really identical. It's not the same.
How classification issue is maintainable before this court? You have to go before the Honorable Apex Court. How under 35G the classification issue is maintainable? Yes, this is the matter. By next week. By week after next, as prayed. Yes. So,
For 2 weeks time, my lord, AG will appear and argue in this matter. AG will appear and argue in this matter, my lord. Pray for 2 weeks time, my lord. We're engaging ASG.
You are engaging?
ASG.
AG na?
ASG.
ASG.
Pray for 2 weeks time.
Is the matter by week after next, as prayed by the learned counsel appearing for the appellant. What is the matter?
Because challenging the order of classification based on finding appeal against that order.
In this matter, you have sought to refer the matter to the full bench.
No, my lord, not in this matter.
Not in this matter.
Another writ appeal, not in this.
Yes, speak after next.
The case where retrenchment compensation has been awarded to the respondent. Actual submission is here there was no formal appointment. She was just working for as a domestic help in the office for 2-3 hours a day. And she had stopped coming to work and he had engaged another domestic help. So before the CJT, she is referred for reinstatement and retrenchment compensation. Now, the Honorable Tribunal has awarded retrenchment compensation. As per submission is there was no sanctioned post. Absolutely, it is covered by Uma Devi versus State of Karnataka, the Constitutional Bench.
This order is dated 31st December 2020.
Yes, madam.
When the award has been notified.
Notified.
The order shall be completed within 30 days of publication of this award.
Yes, madam. 8/2/2021.
8/2/2021.
Because of COVID and other
Already 1 year lapsed.
Because of COVID and other things, we could not file it. But basic point is, not she was only a casual employee. Your lordship may go through the parrot, the learned judge herself has observed in
from 1984 to 2011. Retrenchment compensation.
In page 43, my lord, of the judgment.
Yes.
In page 43. Which was only.
Say notice.
Kindly stay.
No. Where is the application for stay?
Interim order is
petition.
Criminal.
Not at this. You will take out emergent notice. Not at this stage. Already, even after the publication of the award, it's already 1 year lapsed.
Of this COVID, this thing we.
Only there is no reinstatement. Only the compensation to be paid.
Sanction post
Correct. Other no without hearing the nothing but staying the order means almost it is putting an end to the litigation.
Criminal action initiate.
Yes. Hardly agabartare. The emergent notice issue ಮಾಡಿದೆ. ಇಲ್ಲ ಈಗ ಅದ್ಯಾವುದೋ ಇತ್ತು ಅಂತಲ್ಲ ಇದೆ ಅಂದ್ರಲ್ಲ ಫಾಸ್ಟ್ ತಕೊಳ್ಳಿ wait sir. Yes, sir.
Just take 2 minutes to explain why we have done it.
Where is the memo?
Came up in the morning hour, then not speaking. Just take only 2 minutes to explain.
Yes. Yes, sir.
Additional documents that have been filed before my lord. It's 8 of the additional set of documents. Just take 2 minutes to explain.
No, normally in the High Court, anything for that matter, if taken on record, it should be type written, sir.
What happened? I'll tell you why we are having say
No, we will follow you to withdraw it. Why should we go at the merits of the case?
I am not asking about to I'm only explaining your why.
No, why it doesn't matter why you are withdrawing. You are the master of your case. If you want to withdraw it, you are at liberty to it's not a public interest litigation.
one by us.
Ah.
This is the borrower. And the bank.
Yes.
Both are against the same DRATs only.
Yes.
One portion of thereafter, the bank and we both are come to one-time settlement. Then we have to pay about.
Now what about 12161 of
That also
2000?
your lordship is being withdrawn. There is a memo, your lordship, that is being filed for that also. We have an assurance from the bank's council also.
Where is the council?
Your Lordships, I appear for the respondent, Your Lordships.
Ah. You are withdrawing your writ petition also?
We will withdraw by in the course of the day. We will file memo, Your Lordships, to withdraw the matter.
Yes. File it, sir. Immediately
Please,
you file it.
Please, Your Lordship.
Yes. Then we will close both the matters.
Please, Your Lordship.
Reason only your lordship is this. I am not troubling my lords on that at all.
No, we will not record any reasons.
My lord can simply say in terms of this memo,
Yes.
these writ petitions are withdrawn.
Yes.
Because the difficulty your lordship is once you withdraw, then you have to get the release of the documents of the property. That's the reason your lordship, it came up before 2 weeks before. I mentioned this. My lord supposed to which therefore this matter can be disposed of in terms of this memo, because we have paid the one-time settlement, whatever amount they asked us, that has been paid within the time. So all that we are waiting your lordship is only for the release of documents and the property. That only thing that
So
remains.
settlement agreement is already there. In view,
That is what your lordship I want to point to my lords.
Yeah.
That is the settlement deed I want to point to.
so we will permit you to withdraw in terms of this memo.
Yes. Settlement deed mentioned in the memo.
Where is the settlement?
That's what I was pointing out. My lords kindly see page 8.
Page 8 of
Set of documents that are required. 17. Lord, know what is there in the settlement?
page.
17.
Ah. Yes.
My lord can come to page 18.
Yes. Ah. Ah.
Because of special circumstances, we hereby agree to propose to settle all the 3 loan accounts on payment of rupees 2,41 lakhs. They give us the dates.
Ah.
Before 28th of February, 1,25 lakhs, and 1,16 lakhs on or before 7th of March 2022.
Yes.
And thereafter, I also kindly see there are 3. There are payment of the entire amount. The bank shall release the mortgage, the properties, and release the and for all this purpose, you will get the amount. This has been complied with your lordship, which my lords will find at page number 10.
Yes.
Has been complied.
Yes.
So we are only your lordship in terms of this. My lordship kindly see page number 10.
Ah.
At page number 12.
Yes.
Page number 11 and 12. There are 4 your lordship, 1,25 lakhs has been paid, and paragraph 5, 1,16 lakhs has been paid. So 2,41 lakhs has been paid.
So why this validity of this letter is only up to 7/3/2022?
Because they want us to make the payment before that particular day.
Ah.
In order for the
So
one
you
time.
made it.
That's what I'm pointing out. 2nd March we paid it. 2nd March we paid.
Where?
Instead of 7th, which is there at page number 11. Now you see 2 tables, paragraph 4 and paragraph page 11, paragraph 4 and paragraph 5.
Ah.
Therefore, my lords will see 1,25 lakhs, date of deposit 28 February. Next one, paragraph 5, 1,16 lakhs, date of 2nd of. So before 7th month, that has been paid. So one time settlement has been honored. So therefore, the repetition effectively becomes redundant. And their repetition also becomes redundant. Only what remains is to formally take it on record, is to get the repetitions being disposed of in terms of settlement deed. Then all the consequences.
You have to mention the settlement deed date at least. No, handwritten memo. File it, sir.
28 February is the date.
Yes. Shall we close it, bank of council?
Please, Your Lordships. We don't have any issues. We
Your
undertake to
case also.
we undertake
Your
to hand
case
over the
also.
documents within 15 working days, Your Lordships.
Yes.
From today.
That is what, but what we are fighting for is only that release of the document and the property.
Within?
Release of the documents and the property.
Correct. Within what date? We will not record.
15 days you are saying.
15 days.
Within 15 working days, Your Lordship.
But you mention it in your memo.
Please, Your Lordship, I will mention that same in my memo and I will undertake to hand over the documents within 15 days, 15 working days. In the course of the day, I will file the memo in the office.
File it today itself.
Yes, please, Your Lordship, today itself.
And counsel for the parties. Fine. Withdrawal of their respective writ petitions. In terms of the, in view of the settlement agreement, dated February 20, 2022, entered into between the parties. We complied with. We complied with.
As required in the settlement deed itself.
We complied with. For the terms of the settlement agreement. Of paper. Record. Petition. What are petitions? Post of. In terms of both the parties. As of who said. Date 28 to 22.
Obviously, order to be served on the the order you not but what now that the matter is simple, I can find out only one thing. Gets 2.41 crores, we have taken private. Gets 2.41, we have taken private. Now we are asking the bank about.
No, let him file it, sir. At least we must take it on record. How can he sign it without his memo being there on record? Yes, sir. Can you take this settlement deed as part of your memo? Huh? No, this IA we will, instead of taking this IA, you can file this along with the memo.
We filed the additional set of documents, civil encroachment.
No, now you have filed a memo. Along with that memo, you take, we will take it on record. Well, London Council has filed a memo seeking withdrawal of their both the London Council and the London Council for the and then London Council for the petition 1905 of 2018 has filed a memo. Letter dated 8/3/2022 sent by the correspondent bank, enclosed along with its annexes and copy of RP and the acknowledgement slip. The complaint and it council 12161 of 2018 has memo seeking withdrawal of the writ petition. Separate the petition. Learned counsel appearing for both the parties have filed their respective memos ತೆಗೆದುಬಿಟ್ಟು separated ಹಾಕೊಳ್ಳಿ separated memos filed ಅಂತ. This letter dated 8/3/2022, or instead of all that, you would have indicated the settlement memorandum of settlement dated so and so. Why you make it so cute, sir? You will say that instead of all this, you will say the settlement of agreement dated. That's all. Why should we go to that letter and all? That would be suffice. Has filed a memo along with the copy of the settlement agreement dated February 28, 2022, and the letter. What is that? When you have made that in 2 installments, and the letter dated 8/3/2022 is under settlement agreement dated February 28, 2022, and the letter dated so and so. Yes. Kindly send it through mail, or if it Mr. Counsel for the bank.
Yes, Your
memo.
Lord. Please, Your Lord.
And you have to make it very clear that we will release the original documents within 15 working days.
Yes.
As you submitted. Yes.
I will mention in the memo.
Yes, sir.
Please, Your Lord.
All the pending IS can disposed of accordingly. Consumer forum matter.
On the compliance of the order, compliance status of the order.
Want to file reply. What is that affidavit?
The district consumer forum had passed an order, and by the impugned order, the petitioners have been imprisoned for 2 years, Your Lordship, for non-compliance of the order. So, Your Lordship, on the last occasion had permitted me to file an affidavit stating the status of each compliance of the order, which I have done. Your Lordship. This is regarding the question of whether the non-compliance should be deliberate for awarding punishment under Section 27 of the Consumer Protection Act. But if I filed my affidavit regarding the compliance
Of your order passed. So according to you, there is no willful default, willful breach, willful disobedience.
Yes, Lord. My argument is that under Section 27, exercise of power can be done only if there is a determination that the non-compliance was deliberate and willful, which is not been done by the impugned order.
What is the complaints that was required to be done by them?
Order is of 2013, Your Lordship. Additional documents starts from page number 10, Your Lordship. Section 3. At page number 42.
What happened to the execution petition? Status of the execution petition? Of March. What about that clubhouse? All that the other day the learned council submitted that they have complied with and all that recreation play area.
There is no
Page?
Page 2 of the affidavit has been. First is regarding the completion certificate, Your Lord. On that, I had submitted that this issue is pending before the Supreme Court and there is a blanket state order for the entire state of Karnataka. So there cannot be any regularization while this order is in force, Your Lord.
So this petitioners they are at Mumbai, yeah? Where is the project located?
Bangalore, Your Lord.
Which Mangalore?
A project, Your Lord, with about 38 lakhs.
Do they have any other trade name or some for this project? No.
Your Lord, this is the only project. Your Lord, the other constructions are not aware of. Constructions are not. At page 4, the affidavit. Because, Your Lord, the affidavit states that the internal works could not be carried out because they were not permitted to enter the flats, Your Lord.
Let him file the reply. Learned counsel for the respondents to file reply to the affidavit filed by the petitioners. Is the matter week up to next as prayed.
Requested a fixed date.
Sorry.
But the execution petition, they will be arrested, Your Lord. If the warrant is issued.
Don't precipitate the matter in the execution court on the next date of hearing because you are seeking time to file the reply. Yes.
For the respondent, my lords, in this matter, In this matter, we have also filed one writ petition, my lords, 6252 of 2022.
2022.
Yeah, please, my lords. 6252 of 2022.
Writ petition number. Whether what is the stage of the writ petition, madam? Whether it was listed before the court?
No, no, my lords. No, my lords. It was not listed. It was not listed.
Let it be listed. Then we direct it by next week.
Oblige.
We direct you then to accept notice. Yes.
My lord, I beg to appear for respondent in this matter, please, my lord. In fact, my lord, this matter was there about 2 weeks back before your lordship. My lord, since Mr. Patil, my lord, Vijay Kumar Patil, was appointed as amicus, because he was present in court, but since party in person was not there, it was adjourned to today.
Where is Mr. Vijay Kumar A. Patil? Today, Mr. Vijay Kumar Patil amicus is not present. The party in person is present before the court.
My lord, if my lords could take up the matter, I am ready. Only thing is, my lord, this court appointed Mr. Patil as amicus, and he's also filed his written submissions along with list of authorities. He said he was ready last time to address arguments, but matter was adjourned.
Pass or let him bring Mr. Vijay Kumar Patil. To get him.
Please.
24, 25, 26, 27.
Senior Secretary Kesavan will appear on his matter by on his legs and another court.
For this next week, sir. Someone mentioned in the morning. Sir.
Kesavan will appear on this matter. He's on his leg in another court. Can we pass over the matter? Afternoon session.
Sir, yes, pass.
Section 29.
We don't have any other matter. 45. Mr. Alur, you are waiting for which matter? Which is that matter? Where is government advocate? Huh? What is the matter? What is the matter? No, no, this is STRP.
Because returns are also there against the tribunal or the department of find
10-3. 10-3. 10-3 are pending. What file could there are other similar matters pending. Then we will admit the matter. Delay.
small maybe about 350 days, 18 months. Given earlier case, same Massachusetts case, it was disposed of. There was only 18 days delay. I not opposing. Was it 18 days? In this particular case, there's Then in STA, 10 of 2021 was disposed of earlier than that. So there was a delay of 372 in this case and delay of 18 days in that case.
What happened to that case? 18 days delay.
That order was passed on March 19.
What happened?
That delay 18 days are not approved.
Correct, sir. On merits, finally.
Merits it was allowed in favor of the dealer. The state has to report that.
That's pending here.
See, connected case. STRP.
Then we'll allow this delay also here. You know how the revenue proceeds with it. Huh? No, especially during COVID-19 period and pandemic, the functioning was hampered, and there was real reasons. No, otherwise also normally these matters with it is lockdown and spread of COVID-19 pandemic is a good reason.
It was sent back to the additional commissioner where the file was waiting for. The reason the matter was completely assorted.
Anyway, the very same assessee's case is pending before this court.
Yes.
Yes. Cannot the delay. Now it's a good reason for this. For even the Honorable Apex Court also has said that you can do the delay this.
The COVID is in 2020, madam. The orders are passed in 2019.
What is the date of the order?
Order was passed on 7/6/2019.
Moving up the files and coming. Yes, yes. I don't know. Accepting the cost for delay of 372 days in filing the revision petition is condoned. I-1 of 2021 is allowed. Then what is the number? Itapila? STRP? This matter. The second matter also same, huh?
Same.
This matters along with that is in STRP 10 of 2021. What we have condoned the delay. So this list this matter along with STRP 253 of 2018 and connected matters. Why only one matter is connected? STRP 26 of 2020.
Well, they are filing it because the tribunal is allowing the different cases. Each separate division.
These matters are talking. Connected matter is already one matter is there. Yes. 230 ಅಂತ ಹೇಳಿದ್ವಲ್ಲ. ಫೈಲ್ ಕೊಡಿ. suppliers. Mr. Chidanand, Mr. Chidanand. Even in the second round, matter called twice, even in the second round, there is no representation. Mr. Matter, next week.
The first one.
We'll admit the matter. What is this amended appeal memorandum? Yes, Mr. Chidanand, you are ready in the matter?
Sharath here.
You are not from Chidanand's office?
No, no, no.
Yes.
Question number 1 to 6. Grant promotion expenses incurred by a legal is a capital expenditure or revenue expenditure.
Yes, it is always there. Yes. It's always there. What are the questions framed by you? In your case?
It is just a reframe question.
Where is that memo? When? When you filed it? Have you filed it earlier? No. It's arising out of the same order. Huh? Both of you are filing appeals. both as revenue and the assessee. Challenging the order dated 29/5/2020 passed by the Income Tax Appellate Tribunal bench Bangalore in appeal proceedings IT in brackets TPA number 489/BANG/2017 relating to the assessment year 2012-13, raising the substantial questions of law. As framed in raising the substantial questions of law, full stop. The both consider following questions of law. The ITA number 200 of 2021 that is amended writ petition that is 1 to 6. ITA number 108 of 2021 reframe the substantial questions of law. 1-5. Separate heading of ITA number 200 minutes also. Yes. Yes, Mr. Sharath.
Yes, Your Lordship, I will undertake to file notice for respondent, Your Lordship, in serial number 17, Your Lordship.
Who's the respondent?
Himalaya drug.
Learned Counsel Sharath S. Sharatha.
Yes, Your Lordship.
Issue notice ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ. Issue notice. Learned Counsel Shri S. Sharatha.
Yes, Your Lordship.
Hearing through virtual mode. Waves of notice to the respondent. TP. Admit the matter. What happened to the matters? Still pending.
May I took notice and can be posted next week, Your Lord?
Admit the matter. TP matter.
Oh, okay. Okay.
Or else you can serve the copies. Let him also go through it. No, whatever it is, Mr. Sanmati is council will furnish the copies on the other side. Yes, this the matter by next week as prayed. For the appellant, furnish the appeal memorandum copies on the other side. Yes, this the matter by next week as prayed.
Yes.
Where is Mr. Vijay Kumar A. Patil, amicus, or in he is a government advocate? Yes. Yes. Yes, you are senior counsel, Mr. Prasad. What is the matter?
So the matter arises under the provisions of the Karnataka Tax on Luxuries Act.
Yes. Where is AGA today? He's yes. Why he hasn't come today?
All for your lordship's kind consideration is whether the orders of assessment made are barred by limitation or not.
With respect to submission of the petition, my lord, these are all barred by limitations. Your Lordship will kindly see the order of assessment. But the periods of assessment relate to 2003-4 to 2007-8. But in this case, the petitioner did not file its returns at all. In a case where no returns were filed, whether assessment has to be made under section 6, subsection 3 of the Karnataka Tax on Luxuries Act, or would it fall under section 7, capital A of the said Act? If your Lordship will kindly see the Luxuries Tax Act.
Seven is the escapement.
Lordship. Section 6 is assessment.
Yes.
The Lordship will see subsection 3 to section 6, because all the orders of assessment made in the present matter are all made under subsection 3 to section 6. If a proprietor liable to pay tax under this act fails to furnish a return in respect of any period within the period specified in subsection 1 of section 5, the luxury tax officer shall, after giving the proprietor a reasonable opportunity of being heard, assess to the best of his judgment the amount of tax, if any, due from him. Now, your Lordships will kindly see subsection 7, capital A. Assessment of escape tax, where for any reason the whole or any part of the charges for lodging, charges for luxuries provided in a hotel for residents or others, charges for luxuries provided in a marriage hall, has escaped assessment to tax or has been assessed at a lower rate than the rate at which it is assessed, the luxury tax officer may at any time within a period of 5 years from the expiry of the year to which the tax relates, proceed to assess to the best of his judgment the tax payable on such charges after issuing a notice to the proprietor and after making such inquiry as it considers necessary. Now, if your Lordship notices, there is no period of limitation prescribed under section 6, subsection 3. However, when it comes to assessment of escape tax, the legislature thought it appropriate to fix a period of limitation.
5 years.
That is 5 years. Now, there are two issues that fall from my Lord's kind consideration.
Yes.
Whether the assessment made, even though titled as one made under subsection 3 to section 6, does it in reality be traced to subsection 7, capital A? The second proposition is, even though there is no period of limitation prescribed for making of an assessment, so long as the legislature thought it appropriate to fix a period of limitation for making an escape assessment, to bring escaped assessment to tax, can it go beyond the period stipulated under section 7, capital A is the second proposition. In fact, there is a judgment of the Supreme Court to suggest that if there is no period of limitation prescribed, then a reasonable period has to be demonstrated to be made for the purpose of making an assessment. However, if there is a period of limitation prescribed for making an assessment,
For how many years the account books has to be maintained, that is the reasonable period.
not insofar as the account books are concerned, it can't be in excess of 5 years because of the period.
Which provision deals with that?
I'll just take your Lordship to the relevant provision. In the meanwhile, my Lord, may I invite my Lord's kind attention to a judgment rendered by the Supreme Court.
Now, in how many days, how many years that this 6-3 assessment has been initiated.
Lord, in my case, the years, as I mentioned earlier, my Lord,
3, 4, 7, 2, 7, 8.
7, 8.
But when the proceedings were initiated,
Lord, the notices of the proposition notices were given for the first time on 12/2/2014. 12 February 2014. And all the orders are dated 28 February 2014. The 5 years period is reckoned, my Lord. For the year 2003-4, it expires on 31/3/2009. And for the subsequent year, it is 31/3/2010. And for 5-6, it is 31/3/2011. For 6-7, it is 31/3/2012. And for the last of the year, namely assessment year 2007-8, it is 31/3/2013. The proposition notices are dated 12 February 2014, and the orders of assessment are dated 28 February 2014.
for all the years.
For all the years. Now, this is a citation. It is reported in 70 STC page 122.
You have filed reply to the proposition notice.
No, I did not file reply to the proposition. Straightway, the orders of assessment came to be passed. And no returns were filed also in the case of all the five. In fact, that has been observed by the assessing authority in the order of assessment.
Why you have not taken it in appeal? You would have taken the matter in appeal. Why you have filed? So this is STRP.
This is STRP.
What is the opinion of the tribunal?
Yes. The order of the tribunal is an annexure A.
LTRP.
LTRP. Starts at page 37.
Yes.
Insofar as the period of limitation is concerned, my lord, the ground has been taken at page 40, your lordship sees paragraph 8. Referring to the judgments reported in so and so, the appellant submits that from the reading of the judgments pronounced by the apex court in the High Court, the principle of law which emerges is that in the absence of a prescription of a period of limitation, the same should be concluded within a reasonable period. The ground of limitation urged by the appellant came to be rejected by the first appellate authority on the ground that the issue of taxability in respect of luxuries provided by a club was in vacuum till the matter stood resolved by the division bench judgment of our Honorable High Court. No doubt the matter was pending before the Honorable High Court. The appellant has not filed any writ petition, nor was a party to the writ appeals. Therefore, the first appellate authority has grossly erred in holding that the time taken before the Honorable High Court by the Department of Commercial Taxes and the assessees therein ought to be excluded while computing the period of limitation, especially when the appellant had not approached the Honorable High Court. So this ground was taken, and this has been answered by the appellate tribunal at page 48, paragraph 18, 17 onwards. In support of the submission, the learned counsel for the appellant has relied on the rulings reported in so and so and contended that when no specific period is provided in the statute, assessment or reassessment has to be completed within a reasonable period. Now, the real crux of the dispute involved in these appeals by the appellant is with regard to issue of limitation in concluding the assessment order by the assessing authority under section 6(3) of the KTL Act. It is the contention of the appellant that the provisions of section 7(a) of the KTL Act fixes the time limit of 5 years from the expiry of the year to which the tax relates for conclusion of reassessment order in respect of charges for luxuries which have escaped assessment to tax or has been assessed a lower rate than the rate at which it was assessed. And it is further contended that this provision has to be made applicable even for the assessment under section 6(3) of the KTL Act. This contention of the appellant is unjustifiable and unacceptable for the reason that the legislature has not prescribed any time limit for concluding the assessment order under section 6(3) of the KTL Act, which fact is also accepted by the appellant. The provisions of section 7(a) of the KTL Act are standalone or independent of the provisions of section 6(3) of the KTL Act. The provisions of section 7(a) of the Act would come into play only when there is existence of assessment order under section 6(3) of the Act. In this connection, the judgment of the Honorable Supreme Court reported in so and so is of relevance wherein it is held that the power of reopening an assessment either for reassessment or underassessment or escaped assessment could be exercised only if there is an assessment which has already been made. Now, pausing here for a moment, the tribunal allowed itself to commit a grave error to conclude that section 7 capital A would come into play only when there is an existence of an assessment order under 6.3. This is incorrect. If your lordship sees the language employed by the legislature in section 7 capital A, it is titled as assessment of escaped tax, where for any reason the whole or any part of the charges for lodging, charges for luxuries provided in a hotel for residents or others, charges for luxuries provided in a marriage hall has escaped assessment to tax or has been assessed at a lower rate than the rate at which it is assessable. The luxury tax officer may at any time within a period of 5 years from the expiry of the year to which the tax relates proceed to assess to the best of the judgment. So it doesn't use the word reassess at all. Unlike the judgment on which the tribunal purports to rely upon, there very categorically, my lord, the legislature had used the word reassessment. Therefore, in the light of that judgment, the Honorable Supreme Court said that reassessment presupposes that there must have been an assessment in existence. But here that's not the language employed by the legislature. So therefore, even if I don't file my return,
Assessment includes reassessment.
Lordship, that is my respectful submission. Assessment includes reassessment.
Yes.
And assessment of escaped turnover can be subjected to tax or captured for the levy of tax for the first time under 7A as well. Under 6.3, there is a period of limitation under 5 where I need to file my return. Now let us assume for argument's sake, my lord, for the assessment year 2003-4, I should have filed my return by the 20th of May 2004. If I file my return on the 1st of June 2004, then it is not in accordance with section 5 subsection 1. In such a case, it can be captured for tax under section 6 capital within bracket 3. But in a case where no return has been filed at all, it can be captured only under section 7 capital A, and the period of limitation stipulated there is 5 years. So your lordships, Lord asked a question regarding the period for which the books of accounts ought to be maintained. May I invite your lordship's kind attention to section 12 capital B of the Act. Maintenance of accounts and issue of sale bills or cash memorandum. Every registered proprietor and every proprietor liable to get himself registered under this Act shall maintain and keep true and complete accounts relating to his business as well as such other registers or records as may be prescribed in this regard. All such accounts, registers or records shall be retained by him in his safe custody till his assessment or reassessment as the case may be for the relevant year is completed, or in a case where any appeal, revision or other proceeding in respect of such year has been filed and is pending and the same is disposed of. Subsection 2. Every proprietor liable to pay luxury tax under this Act shall issue a bill or etc. So that is not necessary. So therefore, the period of limitation for reassessment is 5 years. So the books of accounts under the Act are contemplated to be retained and kept in safe custody by every registered proprietor for a period of 5 years. Or if any appeal, revision petition, etc. are pending, till such time the matter is disposed of. So your lordship will kindly see the judgment on which the tribunal relies upon. This is a judgment, my lord, reported in 107 page 107 STC page 210. No, this is the judgment on which
So
the
if the
honorable
returns are filed, what is the limitation period? If the returns are filed for this assessment under section 6, what is the limitation for the assessing officer to do the assessment?
There is no period of limitation prescribed.
Even if the returns are filed also.
Even if the returns are filed, there is no period of limitation. However, my lord, in such circumstances, what the courts, including the Honorable Supreme Court, has said is, if there is no period of limitation prescribed for making of an assessment, proceedings, however, shall be done within a reasonable period. And one such reasonable period that can be discerned is from the provisions relating to assessment of escape turnover oblique reassessment. If there is a period of limitation prescribed thereunder, that shall be adopted for the.
Any deferment order was made? Any deferment order was made? Any deferment order was made? No deferment.
Not at all. Not at all. No order of deferment. The reason why this entire thing got to be kept in limbo was some assessees agreed by the amendments brought about to the KTL Act challenge the correctness and constitutional validity of these provisions by filing writ petitions to this honorable. This honorable court rendered a judgment, the learned single judge, in favor of the assessees. State feeling agreed carried the matter in appeal, and the division bench reversed the judgment rendered by the learned single judge and upheld the constitutional validity. It was post that the department woke up to start initiating proceedings for recovery of taxes. I was not a party to either the writ petition or the recovery.
What is the date of the judgment rendered by the division bench?
Yes.
Where is that order?
Yes.
Which provision was challenged?
If your lordship will kindly turn to page 111, Annexure D. This is the order passed by the learned first appellate authority. It's dated 29/7/2017. And what was challenged in the writ petition? Your lordship will kindly see page 113. Para 6. In order to appreciate the issue involved in these appeals, it would be of relevance to reproduce section 3 capital B and the provisos contained therein, which has been substituted by Act 3 of 2004 and deemed to have been substituted with effect from 1/4/2003, which reads thus: 3D. Levy and collection of tax on luxury provided in a club. There shall be levied and collected a tax on luxuries provided in a club to the members who are required to pay any amount as fee, deposit, donation, or any other such charges by whatever name called at the rate specified in column 3, etc. Corporation area, there is one rate, and other areas, there is another. Then your lordship will kindly see page 114, paragraph 7. In confirming the proposed levy of tax under section 3D of the KTL Act 1979, on the total number of members enrolled in the club by levying tax at
So Henry Banaswadi Cosmopolitan, court officer, 2011, 70 K.
So the revision bench judgment, your lordship will kindly see.
You have it?
Yes.
So January 19, 2011.
Lordship is the division bench judge. And to my knowledge, my lord, this was not carried in appeal, further appeal to the apex court.
The proposition notice is dated 12/2/2014.
In fact, unlike the provision under the Karnataka Value Added Tax Act, there is no similar provision in the KTL Act, where, my lord, assuming upon suffering an order of assessment, I challenge the correctness of that by filing either a first appeal or a second appeal. The time taken before the first appellate authority or the second appellate authority shall be taken out for the purpose of computing the period of limitation. The lordships have seen that in the provisions of Karnataka Sales Tax Act, Income Tax Act, as well as the Karnataka Value Added Tax. Similar provision is absent, number one. Number two, I have not subjected myself to any writ petition or written. I was never a party before this honorable court. They could have proceeded against me even if the matters were pending, even if there was an interim order of stay. That could not have operated in my favor because I am not a party before this honorable court.
Yes.
So therefore, my lord, the assessing authority not having made the assessments in time, the respectful submission of the petitioner is that it's barred by limitation, and consequently, my lord, the levy of penalty as well will have to be set aside. So your lordship will kindly see the judgment rendered by the Supreme Court in the case of Bharat CH-3 Limited. Now, this is the judgment I relied upon before the tribunal. It is reported at 70 STC page 122, and the relevant paragraph is at page 130. Last paragraph in that page, which opens with the phrase, the short question that really falls for examination. Page 130.
Yes.
The short question that really falls for examination in this case is whether an order of assessment under subsection 3 of section 11 of the Punjab Act or section 28(3) of the Haryana Act can now be completed or would that be barred by limitation. Undoubtedly, the assessment proceedings have been very delayed. As the material case before us shows, the assessee had gone before different courts from time to time to ask for injunction against the completion of assessment. But that trial appears to have started in December 1980 when a suit was filed and injunction was obtained. Though notices were issued under section 11(2) of the Punjab Act or 28(2) of the Haryana Act within a reasonable period from the filing of returns for the respective quarters in the assessment years under consideration, further question has not been taken by the assessing officer to complete the assessment. But as we have said above, in the absence of any period of limitation, the assessment has to be completed within a reasonable period. What such reasonable period would be would depend upon facts of each case. One view can be that it should be a period not exceeding 5 years, as the legislature has fixed the limitation of 5 years for completing assessments in the case of escaped turnovers. Similar language has been employed in our act under section 7 capital A. Unless there be an assessment made soon after the period to which such assessment relates, the question of considering of escape assessment would indeed become difficult to consider in the exam. So therefore, in my respectful submission, my lord, this judgment is an authority for the proposition that notwithstanding there being no period of limitation prescribed for making an assessment under subsection 3 of section 6 of the KTL Act, the assessments have to be made within a reasonable period. But in a case where no return has been filed, that would fall clearly under the umbrella of the phrase bringing to tax escapement of tax. So that would clearly come under 7 capital A, where the period of limitation prescribed is 5 years. Even if, conceding for a moment without admitting, that it is only subsection 3 to section 6 that can be called in question insofar as the assessee's returns are, insofar as the assessee's assessments are concerned. Even then, no period of limitation having been fixed by the legislature has to be made within a reasonable period. What is the reasonable period can be discerned from the language employed by section 7 capital A. That's my respectful submission. It's 5 years. Now, in the instant case, as I mentioned to your lordships a little earlier, the periods 2003-4 to 7-8, the last of the year, is 31/3/2013, within which the assessments would have been made. And the proposition notices were given for the first time on 12th of February 2014.
And the orders are all dated 28th of February 2014, which in my respective submission would all be barred by limitation. Now the Lordship will kindly see the judgment relied on by the tribunal. Now this is the judgment on which the tribunal relied on and allowed itself to commit an error in my respective submission. Your Lordships will kindly see page 49 of the paper book. Right on top, your Lordship sees in this connection.
So in this division bench judgment, kindly come to the operative portion of the order.
The Lordships are referring to Manaswadi passing.
Yes, sir. All the writ appeals are allowed.
All the writ appeals are allowed. The interpretation placed by the learned single judge insofar as section 3D is concerned is hereby set aside. Consequently, all the assessment orders passed by the authorities are restored. However, the orders imposing liability prior to March 1, 2003 cannot stand and consequently it is set aside. If there are no assessment orders passed yet, the authorities are at liberty to issue proposition notices, hear the clubs, and pass the assessment orders in accordance with law.
As it comes in your way, this observation
I'm not a party to the case.
Even then.
But this can't be held against me for the reason I have not challenged the correctness of the constitutional validity of 3 capital D. It is only insofar as the assessee is concerned before the court who enjoyed an interim order in their favor. And my lord, the learned single judge's order was in their favor. That's how that particular paragraph came to be observed by the lordships of the division bench of the Honorable Court. Now the lordships will kindly see, my lord, page 49 of the paper book. This is the order passed by the tribunal. The words in this connection at page 49. The order of the tribunal as to why they negate my contention with regard to period of limitation. The third line from the top, which opens with the words in this connection. In this connection, the judgment of the Honorable Supreme Court reported in 107 SCC 210 is of relevance, wherein it is held that the power of reopening an assessment either for reassessment or under-assessment or escaped assessment to be exercised only if there is an assessment which has already been made. Now, the honorable members of the tribunal relied on this judgment to say that the question of escapement of assessment, namely 7 capital A, can be pressed into service only if there is an order of assessment and not otherwise. Now, your lordship will kindly see 107 SCC 210, 3 judgments of the Honorable Supreme Court. The relevant paragraph, my lords, is at page 3. I'm sorry, paragraph 3 at page 211. The notices and subsequent proceedings under section 19.
Which judgment you are reading?
Lord, I'm reading 107 SCC 210. Name of the case is Commissioner of Sales Tax versus Filter Company.
Yes.
Dated 4th September 1997. Yes. Para 3, your lordship sees. The notices and subsequent proceedings under section 19 are not on record before us. But it is clear from what has been stated by the board and by the High Court that the assessments that are in the challenge were made upon the strength of the provisions of section 19 of the State Act. The relevant portion of section 19 reads thus: where an assessment has been made under this Act or any Act repealed by section 52, and if for any reason any sale or purchase of goods chargeable to tax under this Act or any Act repealed by section 52 during any period has been under-assessed or has escaped assessment or assessed at a rate, lower rate, or any deduction has been wrongly made therefrom, the Commissioner may,
at any time within 5 calendar years from the date of the order of possession, after giving the dealer a reasonable opportunity of being heard, and after making such inquiry as he considers necessary, proceed in such manner as may be prescribed to reassess. Para 4. It is crystal clear therefrom that it applies only if an assessment has already been made and there has been an under-assessment or escaped assessment there. In a case where there has been no assessment, as in this case before us for the assessment years in question, the provision of section 19 do not apply and cannot be invoked. This is what the honorable members of the tribunal have borrowed in order to negate my contention. My case is not one of reassessment. And that apart from section 7A doesn't employ the word reassess at all. It employs in fact the word assess to tax. So even if there is assessment of escaped tax, it can be brought to the net of taxation by being captured under section 7 capital A. Or even in a case where there has been an assessment made, if the assessment made results in giving a deduction where no such deduction ought to have been made or has been under assessed, even then the same can be captured under section 7 capital A. So to conclude, my lord, my respectful submission would be two pronged. One, even though the assessed period of limitation is not prescribed under subsection 3 to section 6, the period of limitation cannot be in excess of 5 years from the year to which the tax is mixed. Number two, in a case where no return was filed, it would be a case of bringing to tax escape turnover oblique the quantum which is sought to be captured for the levy of tax, and that would come squarely under section 7 capital A, for which a period of limitation is prescribed daily. The case on hand, all the years have been made only in the month of February 2014, which is much after the period of limitation prescribed as matters. So therefore the orders and consequently the levy of penalty orders will also will have to be held as being made after the period of limitation is lapsed. उसमें order. Before even assessment could be completed, after the inspection, discharge the tax act. $5. Yes, sir. Inspection was conducted. After the inspection was conducted.
When the inspection was conducted?
17/5/2007.
17/5?
17/5/2007.
2007.
Yes. Then what's
You might have collected at the gunpoint. You might have collected it at the gunpoint.
Subsequent.
Yes, sir.
Then assessment can come to know that on page 56. Operator has not disputed the tax liability and has paid the taxes before the receipt of funds. The total number of members of the club who are eligible For the area of the tax was provided, and the case have been considered for the tax. The rate of tax also has not been distributed. The operator has not paid insurance which is mandated as per provisions of the Act. Opportunity has been provided to file. However, I would recommend that the judgment should serve. You know, the above assessment concluded service. Our assessment can be concluded to the penalty orders passed for all these years.
No, if the inspection was conducted on 17/5/2007,
yes,
why the proposition notices were issued on 12/2/2014 after 7 years?
I did you pass about
7 years. No, if the inspection, yes, according to the assessing officer, the assessor has not disputed the tax liability and has paid the tax before the inspecting authority. That was on the date of the inspection on 17/5/2007. Then why the proposition notice was issued in the year 2014? What the assessing officer was doing for 7 long years?
because may I request you also to kindly go to 7. Penalty order. It's one of the first penalty order.
87.
87.
Yes.
On page 88, it's supposed to be as operator has not paid taxes as per the provisions of the Act. Proposition is dated 12/2/2014 section 7 of Act. Proposing penalty equal to tax. In response to the above notice, operator has filed a reply dated so. And main points are as under. The delayed payment was due to the fact that the matter was pending before the honorable court. The payment was made in the month of March 2007 and May 2007. But the last paragraph, the reply by the operator has been examined as under. The operator has stated that the matter was pending in the honorable court and it is not paid the taxes in the Act. But it should be noted that the inspection of the business premises was under. But for the inspection and verification of the taxes, escape from the payment of the tax. Our government report was delivered on 28/27 and the proper taxes.
Order was delivered on 20th August 2007.
Taxes in the month of March. Are made to assessment in 3 to 4 7 to 8. The operator has made delayed payment of taxes in section 3 of the after. But for inspection, the delay will not be the tax. But the validity was a challenge. Intention that was what he was not a party. And,
How it is saved, these assessments? There is only on the limitation.
Yes.
Forget about their contentions. Yes.
When there is no allowed specific period of limitation.
How these assessment orders could be sustained?
Submission. And there is no specific period of limitation mentioned for as far as assessment order is concerned. In the absence of pendency of any proceedings before the First, I will say they rely on 7A. That's the statute of limitation for.
No, whatever they rely upon, how this your assessment orders could be sustained by the court? How do you defend your action beyond assuming there is no period of limitation prescribed under section 6(3)? Then what could be the reasonable period? Even if you go by your enforcement authority, before the enforcement authority, it was in 2007. The inspection was conducted on 17/5/2007. Was there any deferment order taken? No deferment order? Have we examined? No, that's very same question we have put to the learned senior counsel. Because of the order passed by the learned single judge in the year 2007, this provision was not at all in existence. So this constitutional validity was upheld by the order of the learned single division bench on 19/2011. So in at least if it is 2011, you might have.
That period, tendency of the proceedings to put this on the report.
Whether any taken, because if you go by this CH-3 Act and this other act
provided for that.
Yeah.
But however, the Luxury Tax Act doesn't provide for that.
There was a provision.
Under
Even under 28(6) also there was a provision to take, if I'm right, if I could case to
Yes, actually, the specific provision is there that on an application being made to the commissioner can make an order of deferment. And that would be taken out from the period of limitation.
Yes. So when the matter is pending before the courts.
A similar provision to the one that was available in the KSC Act is absent in the KTL Act.
Where is the records of the enforcement office? You have the records? Now your grievance is only with the penalty.
Tax as well as penalty.
You have already paid the tax.
I paid the tax.
For the enforcement office.
What?
If you have paid the tax, how can you turn back and say that the tax collected was
the assessment orders made are not traceable to the provisions of the Act. And if they are not, then it becomes void ab initio because it has been passed beyond the period of limitation. I will pay tax on this side. Fails to furnish a because of this Specified in subsection 1 of section 5. The city tax of the shall apply to the reasonable opportunity of the amount of tax if any be from it. Here, but before the assessment orders would be passed, and get down the news.
You paid your taxes in 2007.
On the date of inspection.
You paid, but you are not sought for refund. You are not sought for refund later on.
No, I have not yet sought for refund because my appeals were pending and I was waiting for the outcome of the judgment. And since the tribunal dismissed my appeal.
Immediately from 2007, the proposition notice was issued in 2014. Till then, you have not sought for refund. No, very well, sir. There is a full bench decision of our High Court in this Baghi's case. Once if you have paid the taxes before the inspecting team, enforcement team, cannot later on turn around and say that I'm challenging the action.
Your Lordship will see, my Lord, any collection of tax
without authority of law is against Article 265. Yes, that is correct, but you have voluntarily paid the taxes. Yes,
at the time of inspection, I was persuaded to pay.
But you not acted upon that.
I was persuaded to pay.
SV Baghi's case, what is the citation for government advocate? Baghi's case. Full bench decision is there. Yes.
Even according to the
collected what you are doing for 7 years, sir? Yes. After collecting the tax, what were you doing without passing the assessment order, without quantifying the tax amount?
There is no change in the assessment. There is no addition made into the assessment cost.
That may be true. Now, equivalent to the tax amount, you are making him to pay the penalty. Yes. Yes. Which is the judgment? Do you know that Baghi's case? If I remember, some SV Baghi or something. I ಇನ್ನೊಂದು book ಇದೆಯಲ್ಲ KJ Digest ಇದು ದೊಡ್ಡ book red color ಅದು ಕೊಡಿ 2 books KJ ಇದು Sales Tax Act book ಕೊಡ್ರಿ 2 volumes ಅಲ್ಲಿ ಇದೆಯಲ್ಲ at least he is entitled for that penalty. What were you doing for 7 long years, sir? Enforcement officer has to forward it to the assessing officer to pass the assessment orders. Why he has not passed the assessment order? Who is that officer? Whether he is still working in the department, this officer? Huh? Why he was sleeping over the matter? What is the total tax liability per year? 600 per member. 4,422 members. You collect it from the members. These are all luxury clubs, but only penalty we can set aside.
Penalty came to be reduced by the learned first appellate authority by 50%, and he upheld the balance 50%.
So penalty we can set this. Tax amount you already paid it.
Difficulty would be, my lord, when it is barred by limitation. The question is, can the orders of assessment stand sustained? On legal principle, my respectful submission is in the negative. Because in these LTRPs, it is the tax as well as the penalty that has been questioned. Correctness of the orders has been determined.
There are no additions made in the assessment cost. There has been discharged.
No, whether there was any whether provisional assessment was made by the enforcement officer at the time of collecting the tax. No provisional assessment was made.
The language required in 6.3. As of use judgment, the amount of tax if any due from him or to be assessed. But here in these assessment orders, no additions have been made. Additions had been made.
In the case, assessment addition made or deductions given, that is not the criteria to be examined, sir. Whether it is barred by limitation is the question.
Payment was actually
Self-assessment, where is the self-assessment? That is coming for effect only from VAT period. He has not filed the returns. He has not filed the returns. Yes, yes, he is not. Yes, yes. What is your answer? For 7 long years, you kept quiet without passing the assessment order.
That will not change the position.
Let the officer pay from his pocket. No, let the assessing officer who was sleeping over the matter, let him refund it to the assessee. Correct, sir. From 2007 to 2014, what we understood it. We understood it. What the officer was doing for 7 long years. Over all the officers, let them pay from their pocket.
Payable.
We understood it, sir. Nothing was payable means. So in the KST Act, 12A deals with the reassessment. So in 12A there is a proviso, provided that nothing contained in a section limiting the time within which action may be taken, so and so. Where is the such proviso? Even for the section 12 also it is there. KST Act. Even provided further that nothing in this subsection limiting the time within which assessment may be made shall apply to an assessment made in consequence of or to give effect to any findings, so and so. That is
Baghi's case.
Ah.
It is reported in ILR 1992, Karnataka 1123. That was a case of composition.
Composition.
That is, if you have
whether here any compositions and whether composition order has been passed, you have admitted Antara.
I have only paid the tax. I have not paid the compounding fee. ILR 1992, Karnataka 1123.
You paid the amount, the tax amount.
Compounding is a separate this thing. There is a provision dealing with compounding of offences. I have not gone under the scheme of compounding.
Then where is the records of the enforcement officer? Tomorrow we'll continue it.
Very well.
Please the matter on 22nd. You get the assessment records as well as the enforcement records also. And then when any deferment order was passed and whether that amount tax was paid in the year 2007 after compounding the offense or as a composition is and look at the attitude of your officers. Now we have to answer, sir, limitation. We have to answer. There is no equity in tax matters. We have to answer the limitation. If we answer the limitation, then assessment orders has to be set aside. You can assess at any time. Now, if there is no additional liability, then you can assess after 20 years, after 3 decades or 4 decades. Even after passing of the judgment by the division bench in the year 2011, immediate action was not taken. 2014 proposition notice was issued. At every step, for further arguments tomorrow, get a file, sir. Otherwise, we'll conclude it is barred by limitation as step. Need to ascertain whether there was any deferment or whether there was any opted for the composition scheme or whatever it is, whether he has compounded or not paying the taxes.
ಇವತ್ತಾ? ಓಕೆ ಓಕೆ ಸರ್ ಓಕೆ ಸರಿ ಸರ್.
ಬರ್ತೈತಿ ಟೆಂಪರರಿ ಅನ್ಮ್ಯೂಟೆಡ್
ಇಲ್ಲೇ ವಿಡಿಯೋ
ಬಾಜು ಕ್ಲಿಕ್ ಮಾಡಿ ನಾನು ತೋರಿಸ್ತೀನಿ. ಇಲ್ಲ ಇಲ್ಲೇ ಮತ್ತೆ ಮ್ಯೂಟ್ ಮಾಡಿ ಸ್ಟಾಪ್ ವಿಡಿಯೋ ಮ್ಯೂಟ್ ಮಾಡಿ.
Video off ಆಗಿದೆ. The petition is allowed in part. The impugned order dated 5/5/2020 in CR number 69 of 2008 passed by CJIT from Labour Court Bangalore only insofar as directing to treat the respondent CSE on duty from the date of his superannuation and a monetary compensation at the rate of ₹50 at the rate of 50% of his back wages from the date of his dismissal till the date of his superannuation with the terminal benefits is set aside. The matter is remitted to the disciplinary authority to impose appropriate punishment on charge number 2 and 3 admitted by the respondent CSC. The disciplinary authority shall do the said exercise within a period of 2 months from the date of receipt of certified copy of this order.
Sir. Yes, Mr. Godachi.
I am appearing for the petitioner in this case.
Yes.
I had ಎರಡು judgment to court officer ಕಳಿಸಿದ್ದೇನೆ. I had already placed the 2 judgment before the court officer.
Yes.
Para 12 of the judgment. That is reported judgment Lord this honorable court 107303 of 2019. Para 9, para 12 Lords may kindly should not para 12 of the judgment. Lordship is get it. In the instant case, prosecution has been launched or initiated against the petitioner alleging that they have grabbed the government land in the different blocks of the Baswali village, Halyal Taluk, North Canara district. In all these cases, notices have been issued to the petitioners under section 192 of A of the Karnataka Land Owner Act 1964, calling upon them to quit, vacate and hand over the vacant portion of the alleged government land said to have been grabbed by them. Said notices have been produced along with these petitioners, which is as Annexure A, and it was undisputedly issued between 2011 and 2014. This is basis on which the criminal prosecution has been launched against the petitioners. The application filed under section 9(1) of the Act by the respondent hearing before the jurisdictional court for prosecuting the petitioner for alleged grabbing government land would indicate prosecution has alleged that the petitioners have occupied the government land and thereby they are to be treated or construed the land grabbers or have grabbed the land belonging to the government. One intriguing factors which requires to be noticed that at this stage itself is notice under section 192A of the Karnataka Land Owner Act came to be issued to the alleged encroachers. Petitioner in WP so and so alleged in block number 13 of Baswali in an extent of 2 acres of land petitioner is unauthorized rectification. However, the prosecution has been launched for alleged encroachment to the extent of 5 acres. In almost all these cases, except serial number 7 as indicated in the tabular column, herein below the extent of the land grabbed as per the notices and extent of the land grabbers for which prosecution has been launched varies. Same is tabular below in respect of each cases for purpose of the immediate references. Even para 13, Lord, para 13. Even according to the prosecution, above facts should be disclosed that initially they have alleged that the extent of encroachment was to an extent of 2 acres. However, prosecution has been launched for the larger extent. In other words, prosecution itself was in doubt as to whether the alleged encroachment is to the extent of 2 acres as alleged in the notice or 4 acres or 4 acres 20 guntas or 5 acres respectively as alleged in the complaint. It is in this background the expression or the prima facie as found in the section 11 of the Act would acquire significance. It is prosecution which has to prima facie prove that actual extent of the encroachment of the government land by the accused. In other words, the initial burden is on the prosecution to prove the actual extent of the encroachment by the encroachment, namely the writ petitioners, and thereafter burden would be accused to establish he is not occupation of such a land. In present case, Lord, in the present case, so because evidence of the Tahsildar is not proper because he has not conducted survey and all the spot measure as per the directions of this honorable court, the land grabbing court. Therefore, Lord, the court has acquitted that accused. Therefore, my submission before
Our first question was how the writ petition is maintainable. Writ petition filed by the complainant is maintainable.
Because, Lord, Section 9 of the Act. Section 9 of the Act, Karnataka Land Grabbing Prohibition Act 2011, procedure and powers of the special courts. The special court may either suo motu or on an application made by any person Section 9 law.
And a land grabbing act could land revenue.
Page 458.
Yes.
May I read law? The special court may either suo motu or an application made by any person, Lord. Therefore, not as per the provision of this Lord, Annexure B is my complaint, Lord. Annexure B of the writ petition is my complaint. So, because
correct, sir, the court, special court can initiate proceedings, but however, writ petition is maintainable against that order by the complainant.
Writ petition, Lord, as per the amended act, Lord.
You know, what is the locus of the complainant to challenge that order? You give a complaint to the special court.
Yes.
After you giving a complaint, it is left to the wisdom of the special court to take off, then to proceed. If it is agreed, it is for the state government to file the writ petition, not for the complainant. What is the role of the complainant?
Because in
it's only limited role. You give the complaint, you give the information. This is the land grabbing done here. You give the information. Then it is left to the state government to proceed with the case.
So basically, the complaint, Lord, which is entered into the special court by any person. See,
by any person, you can give the complaint. We are not objecting for giving the complaint. Once the complaint is given, then the proceedings will be taken care of by the state government.
State government
prosecution. Public prosecutor will argue on behalf of you, and the proceedings will state. The cognizance will be taken if it is found to be that is left to the discretion of the special court.
Special court. I got that point of that, Your Lordship. See, that is the point.
State government is not in writ petition. How the complainant can maintain a writ petition before this court?
That is the question. Lord, you have rightly put it, that one, Lord.
That is the question we are putting it to you from last 3-4 occasions to answer that question, sir.
So, because that prosecution are not prepared an appeal before this honorable court.
State government has not preferred any writ petition before this court.
Party has prepared.
They are not. They are the agreed party. They are not in. They have not challenged. How is the locus to challenge?
So that is the point, Lord.
Next, not agenda matter. The point. Repeatedly, we are putting this question, sir, from the day one when we take up this matter. When we have taken this matter.
So I thought that Lord, see whether that complaint is filed by that Lord petitioner, whether it is.
No, complaint can any person can file it. There is no doubt about it.
Is my understanding.
Once a complaint is filed, the cognizance will be taken by the special court.
Now I
the proceedings will be, yes.
What is the difficulty of that one? Because I am not able to to research on that point.
So that is why we refer to Lokayukta case act also.
Please.
Even in the Lokayukta act, a complaint is lodged by a complainant. Then the Lokayukta will proceed with the complaint, and then the action will be taken by the government once a matter is referred. When it is disciplinary authority will be acted upon. Then 12-4 report, 12-3 report, then 12-4 action, the sanction, all that will be taken
Please. Right now, understood that what is the mind of the court, Lord.
Yes. Ultimately, the government is the authority under the Loka Yukta to pass an order of the punishment.
Correct.
The recommendation made by the Loka Yukta there under, but the complainant can challenge the action of the Loka Yukta if the proceedings are dropped, or if the state government action is not proportionate to the quantum of allegations made by the complainant, or is not satisfied by the complainant, then such challenge could be made by the complainant. As far as knowledge, it's not permissible for the complainant to proceed further after giving a complaint. That is why we are specifically referring to that Loka Yukta Act also.
See, because that is not specifically not said in this act. So because that prosecution has taken care of that entire things in that special.
Yes, sir. Yes, prosecution will take care.
Yeah. I got that point of the court. I got that.
Yes, sir. What is your answer? You got that point correct, sir. What is your answer?
Other ಮೇಲೆ research ಮಾಡಿಲ್ಲ ಅದಕ್ಕೆ.
We will not adjourn the matter, sir.
Because
every day for one reason or the other reason, we can't adjourn the matter. It's available for us, we can decide the matter. That's all.
Please.
ನೀವೇ ಹೇಳ್ತೀರಾ? Yes ಅಂತ ತಲೆ. Yes.
Regarding first the court had stated that the repetition was maintained. Repetition is very well maintainable, because the provisions were not there before the amendment.
Repetition is maintainable. Repetition by whom? That is the question. You are also not able to catch that point. Repetition not by the complainant, sir. Repetition has to be filed by the state government. The agreed party would be the state government. Once it is not having any personal interest now in the matter, he is bringing to the notice of the court. This is the situation where the land grabbing has taken place. The public land, the government land has been encroached upon by so and so. He is not having any personal interest in the matter. What is the locus of his complainant to file the writ petition? Both of you are not doing research on this point, sir. From day one, we are requesting you to read this point. How a repetition by a complainant is maintainable before this court. Repetition is maintainable anta ನೀವು ಈಸಿಯಾಗಿ ಹೇಳ್ತೀರಾ. No one is objecting. Repetition is maintainable by whom? That's the question. You are also not arguing on that point. Yes, sir. Next point.
The next point is not the judgment of the special court. There are 18 Lord. In page number 41 Lord. Though it is alleged by the prosecution that the encroachment made by the accused persons was for the purpose of cultivation, the report of the revenue inspector and the Mahajar respectively at exhibit P1 and exhibit P20 are silent about the purpose for which the accused had encroached the government road, as there is no mention about the encroachment for the purpose of cultivation. Lord, the logic of this court, Lord, the only thing is that whether they have encroached or not, that is the only question before them, Lord, special court. See, because the special court has to, Lord, acquitted that accused only based upon that they have not cultivated the land. See, because that the observation made by the special court is not totally unsustainable in eye of law. Then, Lord, see, because the Tahsildar, Lord, as per the direction of the special court, Lord, has conducted the spot Mahajar and he had inspected the bond, and it is proved that because it is encroached by the accused, Lord. So, therefore, Lord, our request before this honorable court is not, Lord, the judgment which is passed by the special court is to set aside and to punish them under section, Lord, the section 4 clause 3. So because Tahsildar himself has not let the evidence before this court, Lord. Lords may kindly see not.
No mention about the encroachment for the purpose of cultivation. Then what purpose it has been encroached?
Encroachment ಮಾಡಿದ್ದಾರೆ ಅವರು. ಅದು that is the not, that is the road which is passes through not Ganjihal to not ಅದು ಅಲ್ಲಿ ರೋಡ್ ಇತ್ತು, ಆ ರೋಡ್ಗೆ ಅದನ್ನ ಕಲ್ಟಿವಿ ಅದನ್ನ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಷ್ಟೇ. They have encroached that road, but the observation of the special court is not, they have not, encroachment is not for the cultivation ಅಂತ ಹೇಳ್ತಾರೆ. So because that wrong observation is made by the special courts. Tahsildar himself has not examined by the special court, but that is PW2 Lord. Annexure 20 ಇದು Annexure G, page number 28 Lord, in page number 20.
PW2 is the Tahsildar.
PW2 is the Tahsildar Lord. He had conducted.
PW2 has not challenged the order of this special court. Tahsildar.
No, because normally not, because the state government officer normally they have not going to not such a serious.
No, government has to do it. It is a government land.
Please.
Yes, government is the agreed party, not you.
Our complaint got to after 2.5 years. They have not initiated any actions. Straight away, my party has lost the complaint before that. Not special.
No village map is produced to show that there existed a road.
Kella kottidare. Ali encroachment agide anta helidare. In his evidence, in his cross examination, Lord, he admitted that there was an encroachment anta helidare. But the only Lord, the special court has observed that Lord, it is not for the cultivation anta heli. They have not.
PW2 deputy commissioner, not the Tahsildar. But evidence of PW2, the correct Tahsildar, that the deputy commissioner for about 20 times has directed for survey of survey number 6, and the same was not done. Deputy commissioner has directed for survey. This suppose a contention of the accused that if at all there was road, it existed in survey number 6 and not in survey number 5. Who has to do this survey?
Surveyor, Lord.
Surveyor.
ಅವರು ಮಾಡಬೇಕು 20 times is directed to go and to survey it. ಆದ್ರೂ ಮಾಡಿದ್ದಿಲ್ಲ ಅವರು.
Then PT sheet, PT sheet, survey sketch is prepared on 10/2/2017 by the Taluka surveyor.
Because he is the competent person, the only
Said surveyor is not examined as witness before the exhibit P2 does not disclose the boundaries of the encroached extent of the road by each of the accused persons, and also the width of the road as such. Either the PW1 or PW2 has spoken about the width of the road. Whether first of all the encroachment is in survey number 5 or survey number 6.
Survey number 6, actually they are the owners of survey number 5. All the accused are the owners of the survey number 5, but encroachment in survey number 6. Number 20, Lords may kindly Lord, judgment, para number 20, page number 42 only. Exhibit P2, PT sheet, sketch is prepared on 10/2/2010 by the Taluka surveyor, which discloses that the extent of the land alleged to have been encroached by the accused persons herein. The said surveyor is not examined as a witness before this court, Lord. The court, Lord, is repeatedly, Lord, direct him to come and to examine, give the evidence before this court, but he did not come to that court. So based upon that, Lord, so he was acquitted for that. Very point, mele acquit ಮಾಡ್ತಾರೆ. So for other things is not the investigation, Mahajar, PT sheet, everything not proved that it is encroachment.
There is no boundary description, no village map. To what extent it has been encroached?
Gunta wise, the total lot survey number 5/2 ದಲ್ಲಿ 14 ಗುಂಟಾಸ್ ಇದೆ. ಸರ್ವೆ ನಂಬರ್ 5/3 6 ಗುಂಟಾಸು, ಒಂದು 7 ಗುಂಟಾಸು, 4 ಗುಂಟಾಸು, 4 ಗುಂಟಾಸು. That much was encroached by the accusers. The report of the Tahsildar Lord lost Miss ID Sim Lord Annexure C. That is the report of Tahsildar which is filed before the Lord.
What is exhibit P13? P13 is the report of the Tahsildar.
Report of
Hungun Taluk.
Exhibit 13. That I had placed that report before Lordship Lord. That is page number.
Page number?
Page Annexure D Lord. Annexure B, page number 16. In page number 16. May I read, my lord? ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ಪ್ರಕರಣ ಸಂಖ್ಯೆ LGCP 21/2017ಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 2ರ ಪ್ರಕಾರ ತಹಶೀಲ್ದಾರ್ ಹುನಗುಂದ್ ಇವರು ವರದಿ ಸಲ್ಲಿಸಿ ಹುನಗುಂದ್ ತಾಲೂಕಿನ ಗಂಜಿಹಾಳ್ ಬೇವೂರು ಸರ್ಕಾರ ರಸ್ತೆಗೆ ಹೊಂದಿಕೊಂಡಿರುವ ಸರ್ವೆ ನಂಬರ್ 5/2, 5/3, 5/4, 5/5, 5/5.
Ganachari was the Tahsildar.
She was a retired Tahsildar.
No, this report was prepared by that same person.
No, not same person, because he is the present Tahsildar who is working in that Hunugund Taluk. He is a regular Tahsildar of that Hunugund Taluk.
This is Tamma Vishwasika Jilladhikarigalu anta ide Deputy Commissioner Bagalkote. Annexure D.
Annexure C, Lord. Annexure C, Lord's Mechanism. Annexure C. Annexure C. Being page
Yes.
number 14.
Yes.
So he was submitted to that Lord. Tahsildar is submitted report to that Deputy Commissioner Bagalkot as per the direction of the special court Lord. So thereafter Lord, the Deputy Tahsildar, Deputy Tahsildar submitted report to that register Karnataka land grabbing court. That is Annexure D.
So when this petitioner was the Tahsildar, when he got retired?
He not before that, before filing. No doubt that Lord, he is the retired Tahsildar and Lord, right now he is working as a president of Srisaila Majjikalajina Padayatrika Seva Samiti anta, that was a registered association. And right now he is presently residing at Ilakal of Hungun Taluk, Bagalkot district. It is not the disputed that Lord, only he has got the complaint only after his superannuation. In the public spirit, Lord, he lost this complaint. So because villagers of the Lord, they have made a complaint.
You got it? Searching, still searching. How long you will take, sir? Yes. Yes, sir.
Complaint is not the Annexure B.
Yes.
Lord, the lost param Lord, the complaint Annexure page number 12 ಅಲ್ಲಿ lost complaint. May I read that one Lord? ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿಸಿದಲ್ಲಿ ಕಾಣಿಸಿದ ಅವುಗಳ ಉಲ್ಲೇಖದಲ್ಲಿ ಕಾಣಿಸಿದವರಿಗೆ ಸಲ್ಲಿಸಿದಂತೆ ದೂರು ದಾಖಲಿಸಿಕೊಂಡು 6ನೇ ಎದುರುಗಾರಿಗೆ ಅತಿಕ್ರಮಣಗೊಳಿಸಲು ಕಳಿಸಲಾಗಿದೆ. 2 ವರ್ಷ 6 ತಿಂಗಳ ಗತಿಸಿದರೂ ಪ್ರಕ್ರಿಯೆ ಕಡಿತ ಇಟ್ಟುಕೊಂಡಿದ್ದಾರೆ. So because they have not yet initiated this complaint which is filed by that Lord, the public and as well as the retired Tahsildars. After lapse of that Lord, finally he lost the complaint before the special court. 1, 2, 3, 4, 5 ಎದುರುಗಾರರು ಹುನಗುಂದ್ ತಾಲೂಕಾ ಗ್ರಾಮ ಗಂಜಿಹಾಳ್ ಸರ್ವೆ ನಂಬರ್ಗಳ ಮಾಲ್ಕಿ ಗುಂಜಿಹಾಳ ಬೇವೂರು ಸರ್ಕಾರಿ ರಸ್ತೆಗೆ ಹೊಂದಿರುವಂತೆ ಎದುರುಗಾರರು ಸರ್ಕಾರಿ ರಸ್ತೆ ಜಾಗವನ್ನು ಪ್ರಕ್ರಿಯೆಯಾಗಿ 9 ಗುಂಟೆ 3 ಗುಂಟೆ 4 ಗುಂಟೆ 7 ಗುಂಟೆ 5 ಗುಂಟೆ ಅತಿಕ್ರಮಣ ಮಾಡಿರುವುದು ಭೂಮಾಕರ ಅಳತೆಯಿಂದ ದೃಢಪಟ್ಟಿದಾಗೂ ಅತಿಕ್ರಮಣ ತೆರವುಗೊಳಿಸಲು 6ನೇ ಎದುರಾಳು ಅತಿಕ್ರಮಣದಾರರಿಗೆ ದಿನಾಂಕ 20/12/2014 ನೋಟಿಸ್ ನೀಡಿದ್ದನ್ನು ಸ್ಥಿರೀಕರಿಸಿ ಅತಿಕ್ರಮಣಗೊಳಿಸಿರುವುದಿಲ್ಲ. ದಿನಾಂಕ 20/12/2014 ಆಸ್ತಿ ಸಂರಕ್ಷಣೆ ಮಾಡುವಲ್ಲಿ ಪೂರ್ತಿ ವಿಫಲರಾಗಿದ್ದಾರೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ 6ನೇ ಎದುರುದಾರರು ಅತಿಕ್ರಮಣದಾರರೊಂದಿಗೆ ಶಾಮೀಲಾಗಿ ಪ್ರಕ್ರಿಯೆ ಜರುಗಿಸಿದ ಕಡಿತ ಇಟ್ಟುಕೊಂಡಿದ್ದರಿಂದ ಸಾರ್ವಜನಿಕರು ತುಂಬಲಾರದಷ್ಟು ನಷ್ಟವುಂಟು ಮಾಡಿದ್ದರಿಂದ ಗಂಜಿಯಾಳ ಗ್ರಾಮಸ್ಥರು ಹಾಗೂ ನಮ್ಮ ಸಂಸ್ಥೆ ದಿನಾಂಕ 25/5/2016 ಸಂಯುಕ್ತವಾಗಿ ಈ ವಿಷಯದಲ್ಲಿ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಕರ್ನಾಟಕ ಸಾರ್ವಜನಿಕ ಆಸ್ತಿ ನಿಗಮಕ್ಕೆ ನೆರವು ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದಾಗ ಯಾವುದೇ ಪ್ರಯೋಜನವಾಗಿರುವುದಿಲ್ಲ. ಘನ ಸರ್ಕಾರವು ಇಂಥ ಪ್ರಕರಣ ವಿಲೇಖರಾಗಿ ಈ ನ್ಯಾಯಾಲಯ ಸ್ಥಾಪಿಸುವಂತಹ ದೂರು ದಾಖಲು ಮಾಡುವ ಭಾಗವಿತ್ತು. ದೂರು ದಾಖಲಿಸಲು ಸಂಸ್ಥೆಯ ದಿನಾಂಕ 29/6/2016 ಜರುಗಿಸಿದ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಅಧ್ಯಕ್ಷರ ಅಧಿಕಾರ ನೀಡಿದ್ದರಿಂದ ಈ ದೂರು ಸಲ್ಲಿಸುತ್ತಿದ್ದೇನೆ. ಮಾನ್ಯರು ನನ್ನ ವಿಚಾರಣೆಗೆ ಅಂಗೀಕರಿಸಿ ಹುನಗುಂದ್ ತಾಲೂಕು ಗಂಜಿಹಾಳ್ ಬೇವು ಸರ್ಕಾರ ರಸ್ತೆ ಅತಿಕ್ರಮಣದ ಕ್ಷೇತ್ರ ಅತಿಕ್ರಮಣದಾರರಿಗೆ ತೆರವುಗೊಳಿಸಿ ಕಾನೂನಿನ ಶಿಕ್ಷೆ ವಿಧಿಸಿ ನ್ಯಾಯದಾನ ಒದಗಿಸಲು ವಿನಂತಿಸಿದರು. ದಟ್ ಈಸ್ ಹಿಸ್ ಪ್ರೇಯರ್ ಬಿಫೋರ್ ದಟ್ ನಾಟ್ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್. Because Tahsildar Lord, he himself was not examined by this prosecution, and he was admitted everything in that cross-examination. There was an encroachment. So despite of the Lord, the special court has not observed all this, not taking into consideration of the evidence of the Tahsildar and evidence of the complaint. Their Lord, the special court has acquitted the accused, Lord.
Kindly come to page 23. The cheat examination.
This is a complaint, PW1.
PW1, last line. ಅಲ್ಲದೆ ಆರೋಪಿತನ ಅತಿಕ್ರಮಣ ಮಾಡಿರುವುದು 2017ರಲ್ಲಿ ATS ಮಷೀನ್ ಮೂಲಕ ಅಳತೆ ಮಾಡಿದಾಗ ಅತಿಕ್ರಮಣ ಮಾಡಿಕೊಂಡಿದ್ದು ಕಂಡು ಬಂತು. ಆಮೇಲೆ ಓದಿ ಫೆಬ್ರವರಿಯಲ್ಲಿ
23 ಪೇಜ್ ನಂಬರ್
ಅನೆಕ್ಷರಿ
ಈ ಪ್ರಕರಣದಲ್ಲಿ ನಾವು ಶ್ರೀಶೈಲ್ ಮಲ್ಲಿಕಾರ್ಜುನ ಪಾದಯಾತ್ರೆ
ಲಾಸ್ಟ್ ಬನ್ನಿ, ಲಾಸ್ಟ್ ಲೈನ್
ಪ್ಲೀಸ್. ಈ ರೀತಿ ಸರ್ವೆ ಮಾಡಿದಾಗ ಇತರ ಅತಿಕ್ರಮಣದವರು ಅತಿಕ್ರಮಣ ಮಾಡಿರುವುದಿಲ್ಲವೆಂದು ಕಂಡು ಬಂದಿದ್ದು, ಅಲ್ಲದೆ ಆರೋಪಿತರು ಅತಿಕ್ರಮಣ ಮಾಡಿರುವುದು 2017ರಲ್ಲಿ ATS ಮಷೀನ್ ಮೂಲಕ ಅಳತೆ ಮಾಡಿದಾಗ ಅತಿಕ್ರಮಣ ಮಾಡಿಕೊಂಡಿದ್ದು ಕಂಡು ಬಂತು. ಫೆಬ್ರವರಿಯಲ್ಲಿ 2017ರಲ್ಲಿ ತಹಶೀಲ್ದಾರರು ಆರೋಪಿತರು ಮಾಡಿಕೊಂಡಿದ್ದ ಅತಿಕ್ರಮವನ್ನು ತೆರವುಗೊಳಿಸಿದ್ದಾರೆ. ಈ ನ್ಯಾಯಾಲಯದಿಂದ ನಿರ್ದೇಶನ ಹೋದಾಗ ತಹಶೀಲ್ದಾರರು ತೆರವುಗೊಳಿಸಿದರು. ಈ ಕಾಲಕ್ಕೆ ನಾನು ಹಾಜರಿದ್ದೆ. ಅತಿಕ್ರಮಣ ಮಾಡಿಕೊಂಡಿದ್ದು ಜಾಗದಲ್ಲಿ ಮೆಕ್ಕೆಜೋಳ ಬೆಳೆ ಇದ್ದುದನ್ನು ಚಿತ್ರೀಕರಿಸಿದೆ. ನಾನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿದ ದೂರು ಅರ್ಜಿಯನ್ನು ನಿಶಾನೆ P1 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ATS machine ಅಂತಂದ್ರೆ ಅದು because now the survey department
the Tahsildar has vacated them from the encroached area.
Vacated, he has vacated. Amen. ಅವರು ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ವೆಕೇಟ್ ಮಾಡಿಸಿದ್ರು. therefore Tahsildar doesn't have any power to punish them. So not subsequent to their complaint has decided to lodge the complaint before the special court for punishment only.
For punishment.
For punishment. Under section 4 clause 3.
Can you read this cross examination? ಆರೋಪಿ ಪಾಟಿ ಸವಾಲು ಆರೋಪಿ ಪರ ಶ್ರೀ SY ವಕೀಲರಿಂದ. ಆದ್ರೆ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಪೇಜ್ 26 ಅಲ್ಲಿ
ನಾನು ಕೃಷಿ ಹಾಗೂ ಶ್ರೀಶೈಲ ಮಲ್ಲಿಕಾರ್ಜುನ
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಕ್ ಬನ್ನಿ. ಈ ಪ್ರಕರಣದಲ್ಲಿ
ವಿವಾದಾತ್ಮಕ ದಾರಿಗೆ ಸರ್ವೆ ನಂಬರ್ ಇರುವುದಿಲ್ಲ. ಅದು ಸರ್ವೆ ನಂಬರ್ 5ಕ್ಕೆ ಹೊಂದಿಕೊಂಡದ್ದು ಇರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 6 ಯಾರಿಗೆ ಸೇರಿದ್ದು ಎಂಬುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 6ನ್ನು 1980ರಲ್ಲಿ ಮಲ್ಲಯ್ಯನ ತಂದೆ ಶಾಂತಯ್ಯನ ತಂದೆ ಇವರು ಖರೀದಿಸಿದ್ದರು ಎಂದು ಹೇಳಿರುವುದು ಸರಿಯಲ್ಲ. ಸದರಿ ಮಲ್ಲಯ್ಯನು ಸರ್ವೆ ನಂಬರ್ 6ರಲ್ಲಿ ಆಸಕ್ತಿಯುಳ್ಳ ವ್ಯಕ್ತಿ ಎಂಬುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 6ರಲ್ಲಿ 120 ಸೈಟ್ಗಳನ್ನು ಮಲ್ಲಯ್ಯ ಮಾರಾಟ ಮಾಡಿದ್ದನು ಎಂಬುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 6ರಲ್ಲಿ ವಿವಾದಾತ್ಮಕ ದಾರಿಯೂ ಇರುತ್ತದೆ ಎಂದು ಹೇಳುವುದು ಸುಳ್ಳು. ಸರ್ವೆ ನಂಬರ್ 5ರಲ್ಲಿ ದಾರಿಯೇ ಇರುವುದಿಲ್ಲ ಎಂಬುದು ಸರಿಯಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 6ರಲ್ಲಿಯೇ ದಾರಿ ಇರುವುದೆಂಬುದು ಸರಿಯಲ್ಲ. ನಾನು ತಹಶೀಲ್ದಾರ್ನಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಸಂಬಂಧಪಟ್ಟ ತಹಶೀಲ್ದಾರ್ ಮೇಲೆ ಒತ್ತಾಯ ತಂದು ಸರ್ವೆ ನಂಬರ್ 5ರಲ್ಲಿ ದಾರಿ ಇದೆ ಎಂದು ತೋರಿಸಿರುವುದು ವರದಿ ಮಾಡಿಸುತ್ತೇನೆ ಎಂದು ಹೇಳಿರುವುದು ಸರಿಯಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 6ರಲ್ಲಿ 2 ಡಾಂಬರ್ ರಸ್ತೆಗಳು ಇರುತ್ತವೆ. ಸರ್ವೆ ನಂಬರ್ 6ರಲ್ಲಿ ಲೇಔಟ್ ರಸ್ತೆ ಬಂದದ್ದು ಅದು 2 ವಿಭಾಗವಾದದ್ದು ನಿಜ. ಸರ್ವೆ ಮಾಡುವ ಸ್ಥಳದಲ್ಲಿ ನಾನು ಹಾಜರಿರುವುದಿಲ್ಲ. ಸರ್ವೆ ಮಾಡುವ ಕಾಲಕ್ಕೆ ಯಾವ ಸರ್ವೆ ನಂಬರ್ಗಳನ್ನು ಸರ್ವೆ ಮಾಡಿದರೆಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಸರ್ವೆ ಸ್ಕೆಚ್ ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ. ಯಾವುದೇ ಒಂದು ಸರ್ವೆ ನಂಬರ್ ಅನ್ನು ಸರ್ವೆ ಮಾಡಬೇಕಾದಲ್ಲಿ ಸುತ್ತಮುತ್ತಲಿನ ಸರ್ವೆ ಮಾಡಬೇಕಾಗುತ್ತದೆ ಎಂಬುದು ಹೇಳುವುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 6ನ್ನು ಸರ್ವೆ ಮಾಡಿದ್ದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 6ನ್ನು ಸರ್ವೆ ಮಾಡಿದ್ದಲ್ಲಿ ಪ್ರಸ್ತುತ ದಾರಿಯು ಅದರಲ್ಲಿ ಬರುತ್ತಿದೆ ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡ ಕ್ಷೇತ್ರಗಳಿಗೆ ದಾಖಲೆಗಳನ್ನು ಮಾಡಿಕೊಂಡಿದ್ದರೋ ಇಲ್ಲವೋ ಎಂಬುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡ ಜಮೀನನ್ನು ಬೇರೆ ಯಾರಿಗಾದರೂ ಕೊಟ್ಟಿದ್ದರು ಎಂಬುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸಾರ್ವಜನಿಕರು ನಮ್ಮ ಸಂಸ್ಥೆಗೆ 2014 ಅಥವಾ 2015 ರಸ್ತೆ ಒತ್ತುವರಿಯಾಗಿದ್ದನ್ನು ತೆರವುಗೊಳಿಸಲು ಸಹಾಯ ಕೋರಿದ್ದರಿಂದ ನನಗೆ ಈ ಒತ್ತುವರಿಯಾಗಿದ್ದುದು ಗೊತ್ತಾಯಿತು. ನಮ್ಮ ಸಂಸ್ಥೆಯು ಇಳಕಲ್ನಲ್ಲಿ ಇರುತ್ತದೆ. ಅದು ನೋಂದಾಯಿತ ಸಂಸ್ಥೆ. ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಯ ದೇಶಿಸುವ ಕಷ್ಟದಲ್ಲಿ ಇದ್ದವರಿಗೆ ಸಹಾಯ ಮಾಡುವುದು. ಸಾರ್ವಜನಿಕರು ನಮ್ಮ ಸಂಸ್ಥೆಗೆ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯ ಜೆರಾಕ್ಸ್ ಪ್ರತಿಯನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ. ಸಾರ್ವಜನಿಕರು ಅರ್ಜಿ ಬಂದಾಗ ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ಪರಿಶೀಲನೆ ಮಾಡಿದ್ದೆ. ನಾನು ಪರಿಶೀಲನೆಗೆ ಹೋದಾಗ ನನ್ನ ಅಳಿಯಂದಿರು ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ 6ರ ಪಕ್ಕದಲ್ಲಿ ಜಮೀನಿಗಿತ್ತು ಎಂಬುದರಲ್ಲಿ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನನ್ನ ಅಳಿಯನ ಹಿತರಕ್ಷಣೆಗಾಗಿ ನಾನು ಸುಳ್ಳು ದೂರನ್ನು ಸಲ್ಲಿಸುತ್ತೇನೆ ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಖಾಸಗಿ ಬಡಾವಣೆಯನ್ನು ನಿರ್ಮಿಸುವಾಗ ಸಾರ್ವಜನಿಕ ರಸ್ತೆಯನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿರುವುದನ್ನು ತೆರವುಗೊಳಿಸಲು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು, ಉಪವಿಭಾಗಗಳು ಮತ್ತು ತಹಶೀಲ್ದಾರ್ಗೆ ಅರ್ಜಿಗಳನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಎಂಬುದರ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶಕ್ಕಾಗಿ ದೂರನ್ನು ಸಲ್ಲಿಸಿದ್ದೆ ಹೊರತು ನನ್ನ ಅಳಿಯನ ಹಿತದೃಷ್ಟಿಯಿಂದ ಕಾಯ್ದುಕೊಳ್ಳಲು ದೂರನ್ನು ಸಲ್ಲಿಸಿದ್ದೇನೆ ಎಂದು ಹೇಳುವುದು ಸುಳ್ಳು. ಪ್ರಸ್ತುತ ರಸ್ತೆ ಸರ್ಕಾರ ರಸ್ತೆಯಲ್ಲಿ ತೋರಿಸಲು ದಾಖಲೆ ಇದ್ದು ಅದನ್ನು ತೋರಿಸಿರುತ್ತೇನೆ. 20/2/17 ಸದರಿ ರಸ್ತೆಯನ್ನು ಪಂಚಾಯಿತಿ ವ್ಯಾಪ್ತಿಗೆ ತಹಸೀಲ್ದಾರ್ ಕೊಟ್ಟಿರುತ್ತಾರೆ. See, that is the evidence cross examination of that retired Tahsildar. The important piece of that evidence is present Tahsildar. PW2 is the important piece. May I read Lord PW2, evidence of the PW2. ನಾನು 14/7/2014 ಹುನಗುಂದ ತಾಲೂಕಿನ ತಹಸೀಲ್ದಾರ್ ಆಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದೇನೆ. ಬಾಗಲಕೋಟೆ ಜಿಲ್ಲೆ ಜಿಲ್ಲಾಧಿಕಾರಿ ಅವರು ಗಂಜಿಯಾಳ ಬೇವೂರು ರಸ್ತೆ ಪಕ್ಕದ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ ಇವರಿಗೆ ಸಂಬಂಧಿಸಿದ ಒತ್ತುವರಿ ಆಗಿರುವ ಬಗ್ಗೆ ಅಳತೆ ಮಾಡಿ ದೃಢಪಡಿಸಿಕೊಂಡು ಒತ್ತುವರಿ ಆಗಿದ್ದಲ್ಲಿ ತೆರವುಗೊಳಿಸಲು ಕ್ರಮ ಜರುಗಿಸಲು ಸೂಚಿಸಿದ್ದರು. ಜಿಲ್ಲಾಧಿಕಾರಿ ಸೂಚನೆ ಅನ್ವಯ 10/2/2017 ಸರ್ವೆ ಸೂಪರ್ವೈಸರ್ ಒಂದಿಗೆ ಚವ್ಹಾಣ್ ಮತ್ತು ಸರ್ವೇಯರ್ನ್ನು ಕರೆದುಕೊಂಡು ಮತ್ತು ETS ಮಷಿನ್ ತೆಗೆದುಕೊಂಡು ಮೇಲ್ಕಾಣಿಸಿದ ಸರ್ವೆ ನಂಬರ್ಗಳಿಗೆ ಹೋಗಿ ಆ ಸರ್ವೆ ನಂಬರ್ಗಳಿರ್ತಕ್ಕಂಥ ಕ್ಷೇತ್ರವನ್ನು ಮತ್ತು ರಸ್ತೆ ಕ್ಷೇತ್ರವನ್ನು ಅಳತೆ ಮಾಡಿದೆವು. ಅಳತೆ ಮಾಡುವಾಗ ಅತಿಕ್ರಮಣ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿತು. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಆರೋಪಿತರು 1 ಮತ್ತು 5 ಹಾಗೂ ಅಂದಾನಯ್ಯ, ಸಂಗಯ್ಯ, ಗಣಾಚಾರಿ ಹಾಗೂ ಮೌಲಾ ಸಾಬ್, ರಾಜ್ ಸಾಬ್, ಮುಲ್ಲಾ ಇವರು ಸರ್ಕಾರಿ ರಸ್ತೆಯನ್ನು ಅತಿಕ್ರಮಣ ಮಾಡಿದ್ದರು. ಆರೋಪಿ ನಂಬರ್ 1 ರಿಂದ 5 ಕೃಷಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ಅತಿಕ್ರಮಣ ಮಾಡಿಕೊಂಡಿದ್ದು ಮತ್ತು ಇತರರು ಅಂದಾನಯ್ಯ, ಸಂಗಯ್ಯ, ಗಣಾಚಾರಿ ಹಾಗೂ ಮೌಲಾ ಸಾಬ್, ರಾಜೇಶ್ ಸಾಬ್ ಮಲ್ಲಾ ಮನೆ ಕಟ್ಟಿಕೊಳ್ಳುವ ಸಲುವಾಗಿ ರಸ್ತೆಯನ್ನು ಅತಿಕ್ರಮಣ ಮಾಡಿದ್ದರು. ಮೊದಲನೇ ಆರೋಪಿಯು ಸರ್ವೆ ನಂಬರ್ 5/2 14 ಗುಂಟೆ ಕ್ಷೇತ್ರವನ್ನು, ಎರಡನೇ ಆರೋಪಿತರು 6 ಗುಂಟೆಯನ್ನು, ಮೂರನೇ ಆರೋಪಿತರು 7 ಗುಂಟೆ, 5ನೇ ಆರೋಪಿತರು 4 ಗುಂಟೆ ಕೃಷಿಗಾಗಿ ಅತಿಕ್ರಮಣ ಮಾಡಿಕೊಂಡಿದ್ದರು. ಕಟ್ಟಡಕ್ಕಾಗಿ ಅಂದಾನಯ್ಯ, ಸಂಗಯ್ಯ, ಗಣಾಚಾರ್ಯರು 9 ಚದರ ಮೀಟರ್ ಹಾಗೂ ಮೌಲಾ ಸಾಬ್, ರಾಜೇಶ್ ಸಾಬ್, ಮುಲ್ಲಾ ಇವರು 18 ಚದರ ಮೀಟರ್ ಅತಿಕ್ರಮಣ ಮಾಡಿಕೊಂಡಿದ್ದರು. ಅತಿಕ್ರಮಣ ಮಾಡಿಕೊಂಡಿದ್ದು ಕಂಡು ಬಂದದ್ದರಿಂದ ಅತಿಕ್ರಮಣದಾರರಿಗೆ 14/2/2017 ತೆರವುಗೊಳಿಸಲು ಸೂಚಿಸಿ ನೋಟಿಸ್ ನೀಡಿದ್ದೆವು. ಅವರೆಲ್ಲರೂ ನೋಟಿಸ್ಗಳನ್ನು ಜಾರಿಗೊಳಿಸಿದ್ದೆವು. 20/2/17 ಕೃಷಿಗಾಗಿ ಅತಿಕ್ರಮಣ ಮಾಡಿಕೊಂಡವರನ್ನು ತೆರವುಗೊಳಿಸಿದೆವು ಮತ್ತು ಮನೆಗಾಗಿ ಅತಿಕ್ರಮಣ ಮಾಡಿಕೊಂಡಿದ್ದವರಿಗೆ ಅತಿಕ್ರಮಣ ತೆರವುಗೊಳಿಸಿಕೊಳ್ಳಿ ಎಂದು ತಿಳಿಸಿದೆವು. 20/2/17 ವಾಸದ ಮನೆಗಾಗಿ ಅತಿಕ್ರಮಣ ಮಾಡಿಕೊಂಡವರು ತೆರವುಗೊಳಿಸಲು ನೋಟಿಸ್ ಕಳಿಸಿದ್ದೆವು. ಕೃಷಿಗಾಗಿ ಅತಿಕ್ರಮಣ ಮಾಡಿಕೊಂಡವರನ್ನು ತೆರವುಗೊಳಿಸುವಾಗಿ ನಮ್ಮ ಇತರ ಸಿಬ್ಬಂದಿಗೆ ಮತ್ತು ದೂರುದಾರ ಅರ್ಜಿ ಸ್ಥಳದಲ್ಲಿ ಹಾಜರಿದ್ದರು. ತೆರವುಗೊಳಿಸುವ ಕಾರ್ಯಾಚರಣೆಗೆ ಸಂಬಂಧಿಸಿದ ಪಂಚನಾಮೆಯನ್ನು ಪಂಚರಕ್ಷಮ ಮಾಡಿದೆವು. ತೆರವುಗೊಳಿಸಿದ ನಂತರ ರಸ್ತೆಗಾಗಿರುವ ಕ್ಷೇತ್ರವನ್ನು ರಸ್ತೆಯನ್ನಾಗಿಯೇ ಉಪಯೋಗಿಸಲು ಸೂಚಿಸಿದೆವು. ಅತಿಕ್ರಮಣ ಮಾಡಿಕೊಂಡ ಕ್ಷೇತ್ರದ ಸರ್ಕಾರಿ ಜಮೀನೆಂದು ತೋರಿಸಲು PT ಶೀಟ್, ಪಹಣಿ ಪತ್ರಿಕೆ, ಪಂಚನಾಮೆಯನ್ನು ಹಾಜರುಪಡಿಸಿದೆ. PT ಶೀಟ್ ಪ್ರತಿಯನ್ನು ವರದಿಯ ಜೊತೆಗೆ ಹಾಜರುಪಡಿಸಿದ್ದು ಅದರ ಅಸಲು ಪ್ರತಿಯನ್ನು ಈಗ ಹಾಜರುಪಡಿಸಿದ್ದು ಇದನ್ನು ನಿಶಾನೆ ಎಕ್ಸಿಬಿಟ್ P2 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. 10 ಪಹಣಿ ಪತ್ರಿಕೆಗಳು ಹಾಜರುಪಡಿಸಿದ್ದು ಅವುಗಳನ್ನು ನಿಶಾನೆ P3 ರಿಂದ P12 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನಾನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿರುವ ವರದಿಯನ್ನು ನಿಶಾನೆ P13 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಬಾಗಲಕೋಟೆ ಜಿಲ್ಲೆಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಈ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿದ ವರದಿಯ ಪತ್ರವನ್ನು ನಿಶಾನೆ P14 ಎಂದು ಗುರುತಿಸಿದೆ. Therefore, there is a clear-cut evidence is given by the plot Tahsildars. He has admitted that it was encroached by the not accused.
Cross examination ನೋಡಿ page 31.
Please, page 31. ಸರ್ಕಾರಿ ರಸ್ತೆ ಅತಿಕ್ರಮಿಸಿಕೊಂಡಿರುವ ಕ್ಷೇತ್ರವು ಯಾವುದೇ ಬೆಳೆ ಬೆಳೆಯಲು ಯೋಗ್ಯವಾಗಿರುವುದು ಹೇಳಿರುವುದು ಮತ್ತು ಆರೋಪಿತರು ಈ ಕ್ಷೇತ್ರದಲ್ಲಿ ಯಾವುದೇ ಬೆಳೆ ಬೆಳೆದಿಲ್ಲವೆಂದು ಹೇಳುವುದು ಸುಳ್ಳು. ಅತಿಕ್ರಮಿಸಿಕೊಂಡಿರುವ ಕ್ಷೇತ್ರದಲ್ಲಿ ಯಾವುದೇ ಬೆಳೆ ಬೆಳೆದಿರುವುದು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಾಜರುಪಡಿಸಿರುವ ಫೋಟೋಗಳಲ್ಲಿ ಕಂಡು ಬರುವುದಿಲ್ಲ ಎಂದು ಹೇಳುವುದು ಸುಳ್ಳು. ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿರುವ ಒಂದು ಫೋಟೋದಲ್ಲಿ ಕಂಡು ಬರುವ ಮನೆಯ ಅಂದಾನಯ್ಯ, ಸಂಗಯ್ಯ, ಗಣಾಚಾರಿ ಇವರದ್ದು ಇರುತ್ತದೆ. ಸರ್ಕಾರಿ ದಾರಿ
ಸಂಗಯ್ಯ, ಗಣಾಚಾರಿ ಇದ್ದಾರಾ ಇಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ?
ಇಲ್ಲ.
Is here before this court?
He is not before this court, Lord.
Why?
He is not before this court.
What is the full name of this ST Ganachari?
Full?
Sangana Basayya. Sangana Basayya. Sangana Basayya Ganachari.
Sangana Basayya Ganachari.
ಇಲ್ಲಿ ಇದರಲ್ಲಿ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿರೋದ್ರಲ್ಲಿ ಒಂದ್ ಹೆಸರು ಸಂಗಯ್ಯ, ಗಣಾಚಾರಿ ಮತ್ತು ಮೌಲಾ ಸಾಬ್, ರಾಜ್ ಸಾಬ್ ಮುಲ್ಲಾ ಇವರು ಸರ್ಕಾರಿ ರಸ್ತೆಯನ್ನು ಅತಿಕ್ರಮಣ ಮಾಡಿದ್ದರು ಅಂತಾರಲ್ಲ. ಹೂ ಇಸ್ ದಿಸ್ ಸಂಗಯ್ಯ, ಗಣಾಚಾರಿ?
He is a resident of Sangaya Andanaya, Sangaya, Ganachari is a resident of not that village, Ganjial Gram.
Is related to this Sangana Basayya, the petitioner here, Ganachari?
He is his relatives, not that. No doubt that he is his relatives. Because he
ಸಂಗಯ್ಯ ಅಂತ ಇದೆಯಲ್ಲ, ಎರಡು ಸಂಗಯ್ಯ, ಗಣಾಚಾರಿ ಅಂತ ಇದೆಯಲ್ಲ. Yes, read it further ಈಗ. ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹಾಜರುಪಡಿಸುವ ಒಂದು ಫೋಟೋದಲ್ಲಿ ಕಂಡು ಬರುವ ಮನೆಯು ಅಂದಾನಯ್ಯ, ಸಂಗಯ್ಯ, ಗಣಾಚಾರಿ ಇವರದ್ದು ಇರುತ್ತದೆ. ಗಣಾಚಾರಿ ಯಾರು? ಇವರೇ ತಾನೇ ಗಣಾಚಾರಿ.
ಅಲ್ಲ, that house is not belongs to that present Ganachari. That I think
Ganachari.
That's the different person. He is the resident of Ganjial village.
ಸರ್ಕಾರಿ ದಾರಿಯನ್ನು
ಅವರು ಇವ್ರಿಗೆ ಟ್ಯಾಗ್ ಮಾಡಿ ಬಿಕಾಸ್ ಹಿ ಹ್ಯಾಸ್ ಗಾಟ್ ಎನ್ ವೆಸ್ಟೆಡ್ ಇಂಟ್ರೆಸ್ಟ್ ಟು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ. ಬಿಕಾಸ್ ದಟ್ ಈಸ್ ದಿ ಇದು ಅದರ್ ಸೈಡ್ ಡಿಫೆನ್ಸ್. ಸರ್ಕಾರಿ ದಾರಿಯನ್ನು ಬೇರೆಯವರು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡ ಆರೋಪಿತರು ತಕರಾರು ಮಾಡಿದ್ದಕ್ಕೆ ಆರೋಪಿತರ ಮೇಲೆಯೇ ಆರೋಪ ಮಾಡಿ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿರುತ್ತೇವೆ ಎಂಬುದು ಸರಿಯಲ್ಲ. ಪಂಚನಾಮೆ ನಿಶಾನೆ P20ರಲ್ಲಿ ಆರೋಪಿತರು ಬೆಳೆ ಇಟ್ಟಿದ್ದರ ಬಗ್ಗೆ ಯಾವುದೇ ನಮೂದು ಇರುವುದಿಲ್ಲ. ಹಳೆಯ ರಸ್ತೆಯ ಪಕ್ಕದಲ್ಲಿ ದೊಡ್ಡದಾದ ಡಾಂಬರ್ ರಸ್ತೆಯನ್ನು 2013ಕ್ಕಿಂತ ಮುಂಚೆ ಮಾಡಿದ್ದಿರುತ್ತದೆ. ಹೊಸದಾಗಿ ಮಾಡಿದ ಡಾಂಬರ್ ರಸ್ತೆಯಲ್ಲಿ ಬಸ್, ಚಕ್ಕಡಿ, ದನಕರುಗಳು ಅದೇ ರಸ್ತೆಯ ಮೇಲೆ ಓಡಾಡುತ್ತಿದ್ದು ಆ ರಸ್ತೆ ಅಗಲ ಸುಮಾರು 30 ಅಡಿ ಇರಬಹುದು. ಹಳೆ ಗಂಜಿಯಾಳ ರಸ್ತೆಯನ್ನು ಯಾರು ಉಪಯೋಗಿಸದೇ ಇರುವುದರಿಂದ ನೀರು ಹರಿದು ಮುಳ್ಳು ಕಂಟಿ ಬೆಳೆದಿರುತ್ತದೆ ಎಂದು ಹೇಳುವುದು ಸರಿ. ಆರೋಪಿತರು ಆ ಕ್ಷೇತ್ರವನ್ನು ತಮ್ಮ ಜಮೀನುಗಳಿಗೆ ಹೋಗಲು ದಾರಿಯನ್ನಾಗಿ ಉಪಯೋಗಿಸಿಕೊಳ್ಳುತ್ತಿದ್ದರು ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಆರೋಪಿತರು ಸರ್ಕಾರಿ ರಸ್ತೆಯನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಳ್ಳದಿದ್ದರೂ ಹಾಗೂ ಯಾವುದೇ ಬೆಳೆಯನ್ನು ಆ ಕ್ಷೇತ್ರದ ಬೆಳೆಯದರೂ ಬೇರೆಯವರು ಹಿತಾಸಕ್ತಿಗೋಸ್ಕರ ಸುಳ್ಳು ವರದಿಯನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸುತ್ತೇನೆ ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಆರೋಪಿತರು ಜಮೀನು ಹೊಂದಿ ರಾಜಸಾಬ್ ಮುಲ್ಲಾ ಸಲ್ಲಿಸಿದ್ದಾರೆ ಎಂಬುದು ಸರಿಯಲ್ಲ. ದೂರು ಅರ್ಜಿದಾರರು ನಮ್ಮ ಇಲಾಖೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ ಎಂಬುದು ನಿಜ. ದೂರು ಅರ್ಜಿದಾರರು ಹುಣಗುಂದದಲ್ಲಿ ತಹಶೀಲ್ದಾರ್ ಕಚೇರಿಗೆ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ ಎಂದು ಹೇಳುವುದು ನಿಜ. ದೂರು ಅರ್ಜಿದಾರರು ದಾರೆ ಸರ್ವೆ ನಂಬರ್ 5ರಲ್ಲಿ ಇದೆ ಎಂಬುದು ತೋರಿಸಿಗೋಸ್ಕರ ಮತ್ತು ತಮ್ಮ ಅಳಿಯನ ಜಮೀನದಲ್ಲಿ ಬರಬಾರದೆಂಬ ದುರುದ್ದೇಶದಿಂದ ನಮ್ಮ ಇಲಾಖೆಯ ಮೂಲಕ ಕ್ರಮ ಜರುಗಿಸುತ್ತಾರೆ ಎಂಬುದು ಸರಿಯಲ್ಲ. ಕಾಲು ದಾರಿಯೇ, ಬಂಡಿ ದಾರಿಯೇ ಅಥವಾ ಪಂಚಾಯಿತಿಯವರು ಮಾಡಿದ ದಾರಿಯೇ ಎಂಬುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸಾಕ್ಷಿಯು PWD ಇಲಾಖೆಯಲ್ಲಿ ದಾಖಲೆ ಇರುತ್ತದೆ ಎಂದು ಸ್ವ ಇಚ್ಛೆಯಿಂದ ಹೇಳುತ್ತಾರೆ. ದಾರಿಯು ಒತ್ತುವರಿಯಾಗಿದ್ದರ ಬಗ್ಗೆ PWD ಇಲಾಖೆಯಿಂದ ದಾಖಲೆಗಳನ್ನು ತರಿಸಿಕೊಳ್ಳುವುದರ ಬಗ್ಗೆ ನನಗೆ ವಿಚಾರ ಬಂದಿರುವುದಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 5ರಲ್ಲಿ ಸ್ಮಶಾನ ಇರುವುದರ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಅಳತೆ ಮಾಡಿದ್ದೆವು. ಆದರೆ ಸ್ಮಶಾನದ ಸರ್ವೆ ನಂಬರ್ 131/2ಕ್ಕೆ ಸೇರಿದೆಂಬುದು ನಿಜ. ಸರ್ವೆ ನಂಬರ್ 131/2 ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 5 ಒಂದಕ್ಕೊಂದು ಹೊಂದಿರದೆ ಬೇರೆ ಇರುತ್ತವೆ. ದಿನಾಂಕ 20/10/2017ರಲ್ಲಿ ಜಿಲ್ಲಾಧಿಕಾರಿ ನಿರ್ದೇಶನದ ಮೇರೆಗೆ ಸರ್ವೆ ನಂಬರ್ 6/1 ಸರ್ವೆ ಮಾಡಲು ಕಳಿಸಿದ್ದೆವು. ಜಮೀನ್ ಸರ್ವೆ ನಂಬರ್ 6/1 ಸರ್ವೆ ಮಾಡಲು ಸುಮಾರು 20 ಸಲ ಜಿಲ್ಲಾಧಿಕಾರಿ ನಮಗೆ ಪತ್ರ ಬರೆದಿದ್ದಾರೆ ಎಂದು ಹೇಳುವುದು ಸರಿ. ನಾವು ಸರ್ವೆ ಕಳಿಸಿದ್ದೇವೆ ಹೊರತು ಸರ್ವೆ ಮಾಡಿದ್ದಾರೋ ಇಲ್ಲವೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 5 ಅಷ್ಟೊಂದು ತುರ್ತಾಗಿ ಸರ್ವೆ ಮಾಡಲು ಏನು ಕಾರಣ ಎಂಬುದಾಗಿ ನನಗೆ ಹೇಳಲಿಕ್ಕೆ ಆಗುವುದಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 5ರ ಭೂ ಮಾಲೀಕರು ಸರ್ವೆ ಕಾಲಕ್ಕೆ ಒತ್ತುವರಿಯಾಗಿದ್ದಲ್ಲಿ ಒತ್ತುವರಿಯಾದ ಕ್ಷೇತ್ರವನ್ನು ಬಿಟ್ಟು ಕೊಡುವುದಾಗಿ ಕೋರಿ ದಯವಿಟ್ಟು ನಮ್ಮ ಬೇಲಿಗಳನ್ನು ಕಿತ್ತು ಹಾಕಬೇಡಿ ಎಂದು ವಿನಂತಿಸಿಕೊಂಡಿದ್ದಾರೆ ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಬೇಲಿ ತೆಗೆಸುವ ಕಾಲಕ್ಕೆ ನಾನು, ಪೊಲೀಸರವರು, ದೂರು ಅರ್ಜಿದಾರರು ಎಲ್ಲರೂ ಹಾಜರಿದ್ದೆವು. ಸರ್ವೆ ನಂಬರ್ 5ರ ಭೂ ಮಾಲೀಕರು ಬೇಲಿಯನ್ನು ಕೀಳಬಾರದೆಂದು ವಿನಂತಿಸಿಕೊಂಡಿದ್ದರು. ಪೊಲೀಸರು ಸಕ್ಷಮ ಒತ್ತಾಯಪೂರ್ವಕವಾಗಿ ಬೇಲಿಯನ್ನು ಕಿತ್ತೆಸಲಾಯಿತು ಎಂದು ಹೇಳುವುದು ಸರಿ. ದೂರು ಅರ್ಜಿದಾರ ಮಾತು ಕೇಳಿ ಆರೋಪಿತರಿಗೆ ಅನ್ಯಾಯ ಮಾಡಿದ್ದಾರೆ ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ದಾರಿಯು ಮುಳ್ಳು ಕಡ್ಡಿಗಳಿಂದ ಕೂಡಿತು ಎಂದು ಹೇಳುವುದು ನಿಜ. ನಾವು ಬೇಲಿಯನ್ನು ತೆಗೆಸುವ ಕಾಲಕ್ಕೆ ಸದರಿ ದಾರಿಯು ಗಿಡ ಗಂಟೆಗಳು ಬೆಳೆದು ಕಾಲು ದಾರಿಯಾಗಲಿ ಬಂಡಿ ದಾರಿಯಾಗಲಿ ಸಂಚಾರ ಮಾಡಲು ಯೋಗ್ಯವಾಗಿರಲಿಲ್ಲ. ನಾವು ಪೂರ್ತಿ ದಾರಿಯನ್ನು ಖಾಲಿ ಮಾಡಿಸಲಿಲ್ಲವೆಂದು ಹೇಳುವುದು ಸರಿ ಅಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 6 ಇದು ದೂರು ಅರ್ಜಿದಾರ ಅಳಿಯನ ಜಮೀನು ಆಗಿದ್ದರಿಂದ ಆ ಜಮೀನನ್ನು ಭೂ ಮಾಪನ ಒಳಪಡಿಸದೆ ಕೇವಲ ಸರ್ವೆ ನಂಬರ್ 5 ಮಾತ್ರ ಭೂ ಮಾಪನ ಮಾಡಲಾಗಿತ್ತು ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ದೂರು ಅರ್ಜಿದಾರನಿಗೆ ಸಹಾಯ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಈ ಪ್ರಕರಣದಲ್ಲಿ ವರದಿಯನ್ನು ಸಲ್ಲಿಸುವುದೆಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಆರೋಪಿತಗಳಿಗೆ ನಾನು ಭಯ ಅಥವಾ ಹೆದರಿಸಿದ್ದೇನೆ ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಆರೋಪಿತರು ಯಾವುದೇ ರೀತಿಯ ಸರ್ಕಾರಿ ದಾರಿಯನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿರುವುದೆಂದು ಮತ್ತು ಅವರು ತೊಂದರೆ ಕೊಡುವ ಉದ್ದೇಶದಿಂದ ಅವರ ವಿರುದ್ಧ ಸುಳ್ಳು ಸಾಕ್ಷಿ ನೀಡುವುದು ಸರಿಯಲ್ಲ. Therefore, this is the evidence of the Tahsildar, cross examination of the Tahsildar.
ಸರ್ವೆ ನಂಬರ್ 6/1 ಇದು ದೂರು ಅರ್ಜಿದಾರನ ಅಳಿಯನ ಮಾಲೀಕತ್ವದ್ದು ಎಂಬುದು ನಿಜ.
ದೂರು ಅರ್ಜಿದ ಅಳಿಯನ ಜಮೀನು
ರಸ್ತೆಯು ಸರ್ವೆ ನಂಬರ್ 6/1ರಲ್ಲಿ ಬರಬಾರದೆಂದು ಮತ್ತು ಅದು ಸರ್ವೆ ನಂಬರ್ 5ರ ಒಳಗಡೆ ಹೋಗಬೇಕೆಂಬ ಉದ್ದೇಶದಿಂದ
ಈ ಪ್ರಕರಣದಲ್ಲಿ ವರದಿಯನ್ನು ಸಲ್ಲಿಸುವುದು ಸರಿಯಲ್ಲ.
ರಸ್ತೆಗೆ ಅಡ್ಡವಾಗಿ ಶೆಡ್ ಕಟ್ಟಿದ್ದಾರೆಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ.
Therefore, he denied all these things.
ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸುವ ಫೋಟೋದಲ್ಲಿ ಕಂಡುಬರುವ ಶೆಡ್ ದಾರಿಗೆ ಅಡ್ಡವಾಗಿರದೆ 9 ಇಂಚು ಕ್ಷೇತ್ರವನ್ನು ಮಾತ್ರ ರಸ್ತೆವರೆ ಮಾಡಿದಿರುತ್ತದೆಂದು ಸಾಕ್ಷಿಯು ಸ್ವಇಚ್ಛೆಯಿಂದ ಸದರಿ ಶೆಡ್ ರಸ್ತೆಗೆ ಅಡ್ಡವಾಗಿ 18 ಚದರ.
What? Some and subtle part his evidence before Lord Special Court is that there was an encroachment. It is an admitted fact.
ಕೊಂಡಿರುವ ಕ್ಷೇತ್ರದಲ್ಲಿ ಯಾವುದೇ ಬೆಳೆ ಬೆಳೆದಿರುವುದು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಾಜರುಪಡಿಸುವ ಫೋಟೋಗಳಲ್ಲಿ ಕಂಡು ಬರುವುದಿಲ್ಲ ಎಂದು ಹೇಳುವುದು ಸುಳ್ಳು. ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿರುವ ಒಂದು ಫೋಟೋದಲ್ಲಿ ಕಂಡುಬರುವ ಮನೆಯು ಅಂದಾನಯ್ಯ, ಸಂಗಯ್ಯ, ಗಣಾಚಾರಿ ಹೊರತು ಇರುತ್ತದೆ. ಖಾರಿದಾರಿಯನ್ನು ಬೇರೆಯವರು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿದ್ದನ್ನು ಆರೋಪಿತರು ತಕರಾರು ಮಾಡಿದ್ದಕ್ಕೆ ಆರೋಪಿತರ ಮೇಲೆಯೇ ಆರೋಪ ಮಾಡಿ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿರುತ್ತೇವೆ ಎಂಬುದು ಸರಿಯಲ್ಲ. ಇದೆಲ್ಲ ಒಂದು ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ತರ ಇದೆ. ಇಟ್ಸ್ ಲೈಕ್ ಅ ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್. ಪಕ್ಕದಲ್ಲಿ ನಿಮ್ಮ ಅಳಿನ ಸರ್ವೆ ನಂಬರ್ 5-6 ಅಲ್ಲಿ ನಿಮ್ಮ ಅಳಿಂದು ಜಾಗ ಇದೆ, ಅಲ್ಲಿ ನಿಮ್ಮ ಮನೆಗಳಿದೆ.
But the only thing is not whether they have encroached this not the land or not. That is the question before this honorable court, my lord.
It's not proved, sir.
That it is proved by the
writ petition and judicial review is limited, sir. It's only under Article 227 we are examining. The scope of judicial review is limited under Article 227. We are not examining the evidence. Just to
that was the observation.
The correct fact, we have read it. It's not required for us to read all this, sir.
See, even that not para 18 of the judgment lord says that not there was encroachment. The only thing is that there was no cultivation of the ಹೇಳ್ತಾರೆ. See, that was the observation of the sessions court, special court.
Yes.
See, therefore special court has not taken the cognizance of not evidence of the Tahsildar and independent evidence of the complainant. ಎಲ್ಲವೂ ಸಿಸ್ಟಮೆಟಿಕ್ ಆಗಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ. ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಎಕ್ಸಾಮಿನ್ ವೆರಿ ಸಿಸ್ಟಮೆಟಿಕ್ಲಿ. ಓನ್ಲಿ ಅಬ್ಸರ್ವೇಷನ್ ಇಸ್ ಲೈಕ್ ದಟ್ ನಾಟ್. So therefore lordship has got that power not to set aside the observation made by special court as per section 17 of the amended act. Otherwise lordship kindly similar section 17A clause 2 dalli
we have seen that is after 2020 those provisions are inserted. That will not apply to the present case. We're not inclined to interfere with orders. Petition stands dismissed.
Synopsis. Synopsis, brief synopsis. Party in person has assailed 2 orders in this writ petition.
Yes.
Please, my lords, his services were terminated by the management.
The morning he was.
He was there. I'm sorry, I was not there. My apologies, my lords. I was on my legs.
Present, but it's not here.
My lords, my kindly, take. Happy to comment.
At the last occasion, the parting person was not present. So to keep all the learned council as well as the parting person, it has become a difficult task for us. There, yes. That is what we were observing just now. To secure the presence of all the learned councils and the parting person together to hear the matter, we should get some auspicious timings. It's not just today. The morning he was present. Yes. From where he has to come? Which place? All the way from Tumkur. We will hear the petitioner. Then let us see. Yes.
This petition is filed by the parting person.
Yes.
Assailing two orders. One, my lords, order dated 5/8/2016 of the disciplinary authority, which is produced as annexure H to the writ petition at page 103. Signed another order of the, which was again challenged before the CGIT at annexure T, dated 22/12/2020. I request my lords to kindly take my synopsis, my lords. Synopsis I have filed, my lords, on 10th February 2022. That synopsis, my lords, brief facts, my lords, I have given. On 20th July 2007, the petition was appointed as the diploma trainee in the Quality Control Department of the HAL Division, Bangalore. Thereafter, my lords, his services were conferred. That cannot be, my lords, relevant. Next page, my lords, next page. When he was discharging his duties on 9/3/2012, one Mr. Sidraju, union leader, assaulted the petitioner, and for that, my lords, FIR has been registered as a crime number 26/2012. Subsequently, my lords, again another date, my lords, 22/6/2015, the petitioner has lodged another complaint in the airport police station on account of ill treatment made to the petitioner by his superiors. Based on this, my lords, these are the background for, my lords, initiation of department inquiry against petitioner. For that reason, my lords, I have given these facts for the Supreme Court. My lords, again I request, my lords, to kindly take the date, last date, my lords, 19/8/2015. The suspension order they issue, my lords. HL issues a suspension order. The petitioner is suspended on ground that he has visited the police station to lodge the complaint during the hours of his duty, pending inquiry by misusing the movement pass dated 30th/7/2015 and 4/8/2015. These are, my lords, two allegations against the petitioner mainly. Then, my lords, annexure M, next date, my lords, is 25/8/2015. Charge sheet, my lords, HL issued charge sheet against the petitioner, which is, my lords, marked as annexure M19. And continuation of M18 on the allegation that the first party had taken the movement pass for the purpose of going to the HL hospital, but instead of going to the HL hospital, he goes to the HL police station and lodges a false complaint against his superiors. Is the allegation, my lords. Annexure R1 to the statement of objections filed by the petitioner, my lords, charge sheet is, my lords, what they have issued, is placed before this honorable court. Thereafter, my lords, I request my lords to kindly skip all these, my lords. I request my lords to kindly take to page 4 of my synopsis. In that, my lords, 2/2/2016 is a relevant date, where, my lords, the management revokes the suspension order. The petitioner receives the order of revocation of his suspension. The respondent has imposed the punishment of stoppage of 2 APIs without cumulative effect and requested the petitioner to join the duty with immediate effect. This is 2 charges. There, he accepts and he has not participated. We are not on that. When the suspension is revoked, subsequent which resulted into issuance of charge sheet, on 10/2/2016, petitioner goes to the office for joining after revocation of the suspension. This is important. The petitioner joined the office upon completion of the term of suspension. The petitioner further releases that his ID card has not been returned, due to which he could not enter the premise of the workplace. The petitioner further releases that the HR department asked him to report to the HAL Elanka division due to his transfer. The said transfer order was ready and he was requested to report to HAL detachment at the Elanka Air Base, which the petitioner did not. Thus, he could not report at the said base and did not. He did not possess the ID card. This is the entire gist of the case. On 10/2/2016, when petitioner goes to the regular place, at the time his suspension was revoked, he goes there and report to the duty. Immediately he was requested to join at Elanka Air Base, saying that you have been transferred. He requests for the ID card. They say that you go there and report, they will issue. He refused to, go there and report to the duty is the allegation what the management makes. On 7/3/2016, the respondent HAL issues a notice of loss of lien, informing the petitioner that he has lost the lien on his appointment under clause 18 Roman 2 of the standing order of the HAL, with effect from 22/2/2016. Additional return to duty, on that day onwards, he remains absent. Standing order says that if he is absent for more than 10 days, he should be treated as unauthorized absence. Thereafter, he writes a reply on 12/3/2016, saying that this is the reason that I have come there. You could not issue the ID card, hence I could not report to the airbase at Elanka. And he expresses inability for the reason that in Elanka Air Base, there are no hospital facilities and my parents are suffering from illness, hence requested to continue there. That request, my lords would get at in this representation dated 12/3/2016. Thereafter, my lords, next date is 6/4/2016. We are Suryanan ex HR of the aircraft division has been appointed an inquiry officer. Petitioner, my lords, participated in inquiry. Those dates, my lords, 5/8/2016. Is annexure H, last column of page 5. A impugned order has been passed, saying that your appointment has been terminated on account of loss of lien, and services were terminated. He challenges that order before the CJIT. Initially, CJIT refused to entertain the petition. He files a written petition. That cannot be again. These dates may not be relevant. CJIT passes the order on 22/12/2020, affirming the order of punishment. For this, my submission would be
CJIT has dismissed
the and held that the department inquiry after providing sufficient opportunity. My submission, I request for us to kindly take page 10 as amicus. 4 points, 5 points, 4 points I have formulated for consideration. He submitted the department inquiry conducted by the last page 10. Is not in accordance with law, as he has not given a fair opportunity of being heard in the department inquiry. Except records reveals that he has participated in inquiry, but he has not adduced evidence except filing the reply to the notices. For that reason, they would have given opportunity of hearing. In the sense, he would have asked to engage services of a co-employee. That option, whether they have availed or they have made available to him or not, it is not forthcoming from the inquiry. That is the one ground. The second one is punishment imposed. 10 days unauthorized absence is highly disproportionate to the misconduct what he has done. Is another second legal submissions what I intend to make. Third one, again, this is a principle that he has made various correspondence Those my lords, correspondence is stand in the reply also is not considered by the in the department inquiry, which has resulted into passing of this harsh punishment. For that, my lords, I referred judgment page 12, my lords. Judgment number 1, my lords, is on disproportionate my lords punishment, proportionality of the misconduct, and punishment should be proportionate. For that, Ranjit Kumar Thakur my lords leads judgment on this point. Page 25, my lords, I request kindly to take para 25 of the said judgment. Lords will get our page 20. My lords, even CJIT has taken, my lords, I'll read 2 paragraphs of CJIT order also. Before that, my lords, what is the scope? Page 20, my lords, para 25 of the order of the Supreme Court on the quantum of punishment. Judicial review, generally speaking, is not a directly against the decision, but directed against the decision-making process. The question of price and quantum of punishment is within the jurisdiction and discretion of the court martial. That is court martial proceedings in that particular. But the sentence has to be suit the offense and offender. It should not be vindictive or unduly harsh. It should not be disproportionate to the offense as to shock the conscience and amount in itself to conclusive evidence of bias. The doctrine of proportionality as part of the concept of judicial review would ensure that even on the aspect on an aspect which is otherwise within the exclusive provision of the court martial, if the decision of the court given to sentence is an outrageous defiance of logic, then the sentence would not be immune from the correction. All those lords, other judgments are para 27 lords. The punishment has been strike, my lords. It says that in the present case, the punishment is so strikingly disproportionate as to call for the justified interference. Here, my lords, the background of the case, why I am referring this judgment is, he has made allegation against my lords, his superiors, and initiation of 2 criminal cases. Appears to be, my lords, one of the weighing factor for the management as well as the inquiry officer to come to the conclusion that, my lords, that his conduct, because for the reason, my lords, I request my lords kindly take the order of the CJIT for a moment, my lords, how the CJIT also is proceeded. On the CJIT order, I request my lords kindly take the order of the disciplinary authority also and also CJIT. Annexure H is the order of the first order of the punishment order, my lords, imposed by the HM. Page 103 of the Annexure H, page 103. Dated 5/8/2016.
103 is
Page number.
something, some letter from Vasu KV to the chief manager.
It's a order, my lords. Annexure H, my lords, I think.
Annexure H.
What is given on that basis, my lords, I am making submission. Maybe very. Dated 5
Huh?
to the writ petition, dated 5/8/2016. The order, my lords, the disciplinary authority. One of the other. Registrars, you were issued with a letter of loss of leave dated so and so for the absence from duty without the leave or permission with effect from 11th February 2016 calling due to return to duty for 10 days from the date of issuance of the loss of leave letter and explanation to and explain to the satisfaction of the management the reasons for your absence for calling which the loss of leave on your appointment will be confirmed. The explanation dated 12/3/2016 submitted by you was found unsatisfactory on one-man department inquiry committee was ordered to be appointed so and so as an inquiry officer to inquire into the alleged charges. Department inquiry first, next para 5 is relevant. This deals with the who is department inquiry report, etc. Para 5, considering all these aspects, case your past record, gravity of misconduct, I hereby confirm the loss of lien or your appointment in HL dated 22/2/2016 under clause 18(2) of the certified standing order of the company, and you lost your lien or the appointment in HL with effect from 22/2/2016. So, para 5 clearly says that considering all these aspects and past record, so the disciplinary authority has proceeded. Mainly, it appears that his past conduct in the department, that he has made police complaint against the senior officers, is one of the factors. This, my respectful submission, annexure H, does not say anything about his reply dated 12/3/2016. It only makes reference related to 12/3/2016. But the contention or the defense taken by the employee is not taken into account by the disciplinary authorities. Another submission I would like to make. Hence, that order may require to interfere, because as amicus, I will not be able to. What is the fact I will be able to place before the court? Then I request to kindly take the order of the CJI, which has confirmed this order at annexure H, page 129 annexure T is the order of the government industrial tribunal from labor court order. Starts with 131. Starts what even CJIT considers all these facts, but also get more finding the issues, what it has framed. Internal page 7 of the order, page 138 is the ink page. Internal page 7, para 4 of the order. In the background, above all, the points arise for my consideration is whether the final order passed by second response against first party work under Exhibit M11 dated 5/6/2016, confirming loss of lien or his appointment with effect from 22/2016 to clause 18(2) of the certified standing order of the company, thereby intimating him accordingly, you lost your lien or the appointment is legal and justified. To this, CJIT considers everything, gives the finding only at para 12 and para 30, para 14 with the finding. Page 21 of the order page 21. Bottom page numbers are there. So I read this para. There is no dispute to the fact that the first party had reported at the gate of the second party on revocation of his suspension order on 10/2/2016. Unfortunately for him, by that time his transfer order was ready and he was required to report to HL detachment at Yelahanka Air Base. He had surrendered his ID card on his suspension and needed an ID card to enter the premises, which was not provided by the assistant officer. He was not prepared to receive the transfer order and report at the transferred place. Thus, was deprived ID card, thereby could not report to duty at his transfer place, that is MSD department. Transfer of an employee is a condition of service, and the employee have not chosen to exercise his option. Then decision of the Honorable Supreme Court to say that it is an incidental service, that is law. I request to the next para 50 is further finding. Of course, on 10/2/2016, he had no ID card to meet his higher officers to make the request for cancellation of his transfer on the ground of personal family problems. But before the inquiry officer, he had ample opportunity to present his case and explain why he was averse to report at the transfer place. The reasons assigned by him that his parents need treatment at HL hospital frequently was insufficient ground for the inquiry officer to accept the
bona fides of his resistance to the transfer order. Rightly, the inquiry officer has observed that the transfer was not to work outside the state, and Yelahanka is very much in the Bangalore city. Even if he had issued with regard to his assignment in Yelahanka, first he should not have received the memo and then taken up the issue with the higher ups concerned authority subsequently. On own showing, first respondent was residing alone at the Bangalore without his parent. It is nowhere said that because of his transfer, his family would be deprived of medical treatment at HAL. HAL being the state-owned aerospace defense company, strict abidance of the employees of the discipline rules is required. He was given opportunity in duly held department inquiry, and all the proceedings contemplated by Rule 18 Roman 2 are complied with second party before confirming the loss of lien of the workman on his appointment. His past record are also not impressive to excise jurisdiction section 11A of the Act. To interfere with the said order, there is no merit claim. Confirm the dismissal order. So only my lords, two submissions again. Going back to the when my lords, they are taking such a harsh action, they would have provided him, my lords, some opportunity, my lords, to adduce evidence. They would have provided him, my lords, a co-employee for assisting him in the department inquiry. That is not done. My lords, hence the principles of natural justice are violated. The inquiry report is silent relating to my lords his stand dated 12/3/2016. What he has submitted reply on that, my lords, no finding.
What is the reply submitted?
Please.
What is the reply submitted?
Reply he has submitted on the ground that, my lords, I could not have an ID card in my hand. For that reason, I was unable to report to the duty.
Transfer order.
Transfer order, that is one.
The transfer order was given, it is consequence of the.
Because what the management witness has deposed, at least he would have taken there and gone there. They would have issued the ID card is the stand.
Transfer order is there, it follows.
When he is a trainee, my lord, lower rank officer in the department, management would have acted, my lord, leniently, my lord, in considering these cases. Only they have, it appears that, my lord, record that past conduct of the employee, that he has lodged the complaint, that itself has waived the mind of the management, appears, my lord, what on the records, and taken the such a harsh decision. And punishment also, my lord, is very disproportionate to the misconduct.
What is most important in these companies?
That is, off the record, I have requested my learned friend, see his, I have heard, I had a discussion with his family members, etc., sisters, and all those. I have made a request that can you, but without back wages or something like that, if they are, at least employment is a difficult thing nowadays. It's kind of lenient.
What is his age now?
Diploma holder plus getting the job is also very difficult.
So the order is 5/8/2016. Commission of loss of lien.
Activation by the labor court.
Is there any possibility to take him back to reinstate him?
Right, our efforts. The written communications was I will take a lot through the standing orders. This is not a case where either minor or major penalty can be imposed. Situation where loss of lien is coming through the standing orders. The only award that can be passed is whether to confirm loss of lien or not. That is the only thing that can be passed in this. But the last occasion I read over the standing orders for just to have a perusal of that one particular clause in the standing order. It is not per se to initiate minor or major penalty proceedings. Whether or not to confirm loss of lien on your account. My lord sees my lord clause 18 of the standing orders.
Termination of employment. The loss of leave is clause number 2. The workman remains absent for more than 10 days or absent himself beyond a period of leave originally granted or subsequently extended. He shall lose his leave on his assignment unless he returns within 10 days of expiry of the notice of termination. Explains to the satisfaction of management the reason of his inability to return before the expiry of the notice. In case the explanation of workman is found unsatisfactory, or the workman does not submit an explanation for this, in order to afford one more opportunity to the company, authorized shall refer the matter to department of inquiry, consisting of one of four persons. Based on finding of department of inquiry, the manager shall pass appropriate orders. In order to days towards in 2016, we will not likely to report to Yelahanka case. Not 7/3/2016, not the standing order says 10 or more days. 7/3/2016, notice of loss of leave which show cause office. He gave his explanation on 12/3/2016. By this time, 1 month period is already passed.
What is the explanation on
12/3/2016? 12/3. By this time, 1 month period is already lapsed. He is neither reported to Yelahanka nor here, or not even come back to ask whether you will issue the ID card. Should I go back here? 1 month period is gone there. On 6/4/2016, since its explanation is not satisfactory, inquiry was opened. 6th of April 2016.
Inquiry was ordered.
Inquiry officer was appointed and departmental inquiry was ordered. But he participated in the inquiry. Lord, he in fact cross-examined the management witness. And Lord, when a question was specifically asked about this defense and production of witnesses, he specifically states that I don't have any defense, I don't have any statement. My Lord will find that statement at page 218 of counter statement filed by the petitioner. So the deal not when it was filed, but it was a take file that the proceedings of the inquiry will not have extracted under this annexure. The relevant page, my Lord, is at page 2 on the page. It's the last date of the hearing, before reserving the matter for.
Second sitting.
Yes, second sitting, 29th April 2016. Before, Lord, I will take the lordship to the cross-examination also, but I just want to read your lordship notice okay. And that Lord is not being given an opportunity to take in his defense. Lord will find at page 21A. If I may read, please, Lord, from the center, the inquiry committee met in scheduled time. The presenting officer submitted that he has concluded the evidence from the management side and he has no more witness or documents to be ready. In light of the conclusion of the evidence from management side, Sri Vasu, workman under loss of leave, was directed to state his defense and adduce any defense witnesses or documents. He also submitted that he has no defense witnesses or documents. Taking into consideration the submission made by the presenting officer and Sri Vasu, both of them were directed to make the final statement. Therefore, to say, Lord, that he has not been given a chance to produce documents of evidence is not incorrect. The obligation on my part, after I have written evidence, Lord, is to permit consent. But we'll find the cross-examination, Lord, starts at page 211 of the very same document, the very same compilation. Paragraph relates to letting in of evidence. Cross-examination starts, Lord, from the middle after the signature. Sri Vasu was directed to cross-examine Srimati Indira Shankar, NW1, if he desired to. Then he continues the cross-examination. In fact, Lord, I will read out a few portions of the cross-examination. Lord, where a specific question was asked as to why the identity card was not issued. Lord, the relevant portions may not be that. Page 212 onwards, my Lord. Page 212, question number 12 onwards, I will read, my Lord. Next page also there are some questions. Question number 12. Is there any practice of maintaining ledger for issuance of ID card? Answer. For issuance of new ID card at the time of initial appointment and the judge's meeting. If ID card is lost, what is the procedure? Not relevant to my deposition. On 10/2/2016, I came inside 1 day pass. How about reporting on 11/2/2016? As per the assignment memo, you were required to Yelahanka base on 11/2/2016. Did you provide any opportunity to meet my higher up boss superiors from 11/2/2016 onwards? It is up to you. I have nothing to say. Security did not allow me to report on 11/2/2016 onwards. What should I do? They were asking for HR permission. If I want to appeal to higher ups about my punishment and assignment, what should I do? No comments. If you had accepted the memo on 10/2/2016, the matter would have been resolved. My lord, again, after clarifying the questions of MW1, if the Vasu had accepted the assignment as per the assignment order, would you have provided him the ID card? Management had issued orders posting the charge sheet and witness to Yelahanka. If he had accepted, necessary arrangements would have been made to issue ID card and Air Force Base Yelahanka pass for entering Yelahanka base. But once the order of transfer is handed over to, it is only after the reports at the Yelahanka base that the new ID card. I am not authorized to give the ID card there. Now, Lord, insofar as the question relating to principles of natural justice, it is fully followed. He's been given chance to be there. The past conduct which my learned friend argued regarding him, just because he gave a representation to his superior.
What is his qualification?
Diploma.
So it is not just the complaint against one superior that was taken into consideration before passing the order. I have along with my statement of objections. Filed, but earlier show cause notice, charge sheets and the order passed by the discriminating authority. Addition R1 and page 51 of the statement of objections. This is not an earlier 2015 charge sheet that was issued. Charge related to willful insubordination or
That is statement of objections, that is different from counter statement.
Yes, sir. Counter statement is filed by the petitioner to my statement. One is the earlier charge sheet issued in the year.
Yes.
But this Lord related to insubordination, obtaining days pass and for medical purposes, but not visiting the inside hospital. But these are the past contents that the inquiry officer talks about. It is not.
Whether he was probationary or whether it was
permanent. He was a workman.
Regular work.
Section R2 at page 22 is the order. If I will not after.
Why he was going to HL hospital for treatment? What problem?
Exactly. If I may read out page 21. He took a movement pass for going to HL hospital, but he never visited. Is one of the charge sheet. And the falsification, kindly see. Para 2 of page 21.
So again, this is he went to the police station to make a complaint.
He takes a pass to go to HL hospital.
No, this is related to the same incident. That is the same charge.
This charge only is pertaining to loss of legal.
Huh?
Loss of legal appointment. So was noticed not, in fact, it was later. I mean, addition R3 and page 23. Notice under which the imputed order.
No, this is the only charge. He went in, taking the moment pass that is going to the HL hospital. He went to the police station and lodged the complaint.
No, that was the earlier charge.
Ah.
The present charge was you find in page 23. This R3 is the show cause notice that is issued on 7/3/2016.
Absenting for duty without
Commission for more than 10 days. From 7/3 from 11/2016 onwards. He has remained absent without therefore loss of leave notice under clause 18 from certified standing. Pursuant to this, Lord, annexure H page 103 is the order which my
So this is unauthorized absence.
in a way unauthorized absence, but there is a specific clause found in the standing orders saying that if he doesn't report for more than 10 days or more, he will use leave on his appointment. This was confirmed by virtue of annexure H page. But labor court, in fact, may not consider this point and gives a conclusion saying that since Yelahanka is in Bangalore, even if he had gone to Yelahanka and made an appeal there could have been some reasoning, some consideration. But he did not report at all for about more than 1 month. Therefore, he cannot now come and contend that the entire order is valid. The relevant portion of the order may not, in fact, my learned friend read the page paragraph 14. Paragraph 15, in fact, at page 155. Page 155.
That we have seen.
Yes, in fact, the only ground that he raised it to the labor court that he had to get his treatment for his parents, but that is also not forthcoming in the defense. He is not choosing to get evidence or producing documents. The stage of
Yelahanka is within the Bangalore city.
in fact, on these issues, specifically relating to loss of lien on appointment, this point came up with consideration to the Supreme Court in a few decisions which I will restrict my argument only on loss of lien because departments are inquiring, there is no dispute about fairness, there is no dispute regarding procedures followed by them. That was a dispute if I only restrict my argument, what is the position of law? Take the loss of lien. But I have filed my list of qualities on 7 pages. What is the first judgment?
When you have filed?
Not on 7/12/2021.
There is some, it is on 20th 12, there are some list of authorities. Gujarat Electricity Board. Yes.
Not the relevant paragraph and not that in page 6. And in this case also, my lord, there was a notice for loss of lien. Giving the absent report also considered the right of an employee to refuse transfer. And what happens pursuant to refusal of acceptance of transfer, whether the management is entitled to levy the penalty of loss of lien. Paragraph 5, if I may read. There is no dispute that the respondent was holding a transferable portion and the condition of service applicable to it was liable to be transferred and posted. Respondent had no legal structure to insist for being posted at a month. In fact, during the tenure of the service, the board of respondent had been transferred from one place to another subject. In March 1974, he was transferred to Surat to employ the district that the places as stated before a sale hearing. The relief from his duty of students on 8 months not join they will do an order of discharge. This is however the service regulation which runs as under the continued absence of duty and overstay in spite of warning but similar to was 18.11%. The above regulation provides that if an employer of contract should be worst in the period of sanction leave and in spite of warning, it fails to return without complying with the procedure prescribed for taking disciplinary action. But you are able to put it and you not even take disciplinary inquiry. Then regulation 113 confers wide powers of the authorities to somebody discharge an employer. It should be acted. And refuses to join should be not. Provides for summary discharge. Two conditions must be satisfied. Firstly, the employee must be found to be absent from duty. object and purpose of giving body is to remind the delinquent employee that he continues to be liable to act under regulation. Even thereafter, if fails to contribute, services are liable to be terminated by the user of the staff. It is noteworthy that the validity of regulation 30 was not similarly, in our case, he has not challenged about the regulation 18. So finally, my lord, at page 11 at para 9, after having these discussions, my lord, the Honorable Supreme Court of India at para 9, my lord says, we therefore hold that the respondent's failure to join his duties as resulted in unauthorized and his failure to join duties out of the repeated reminders and letters issued constituted sufficient valid ground for taking action at the regulation. Further hold before issuing order of discharge, the respondent was not only warned, but he was also afforded an opportunity to explain as to why disciplinary action should not be taken. Therefore, Lord, he cannot now, Lord, come before the labor court and raise a ground that because Lord, I had to examine my parents, Lord, could not be transferred from Telecast, which was not raised before the inquiry officer. He chose not to give evidence, not to produce any evidence. And the judgment, Lord, Union of India was SLR.
Otherwise, also transfer is an incident of service.
I will not but I had cited these judgments for the labor court also. And labor court, Lord, after considering these things, Lord, has passed this. Lord, my Lord, may I request for anything in page 23. Page 25. Just before para 5, about 10 lines from the top, the entire fact situation unvaryingly points out that. I only read required, my lord, because I'm only restricting my arguments to yourself. Point out to one fact may be that respondent flouted the orders of transfer, did not join the place of post, did not apply for or take leave, or his absence, did not discharge his duties. Here the High Court in exercise of its discretionary jurisdiction not only set aside the order of transfer, on the pretext it does not appeal towards with regard to the non-communication of the order.
So the High Court has granted the premium
Yes.
to an errant officer is the view expressed,
Yes.
who did not obey the orders of transfer.
The Honorable Supreme Court did not set aside that order, saying the High Court could not have done that. Doubting of order of transfer itself is not the ground for
Dismissal.
The Honorable Supreme Court of India. Except I will not cover what it is. But powers under Article 226 for interference in disclosure. Union of India was the relevant paragraph note is 30. Where we will explain in detail as to when interference can be done and what could be the grounds for interference. In fact, at para 12, the Honorable Supreme Court of India also records that my lord sees para 12. Even before the inquiry, finding of charge was accepted by the disciplinary authority. High Court is not cannot act as Supreme Court of first. High Court exercise of powers under Article 26 of the Constitution. To reappreciation. I could only see whether the inquiry is held by a competent authority, or there is no dispute. The inquiry is held in accordance with the procedure described in this case. I have taken it also to the inquiry proceedings, not to say it is within authority. There is violation of principles of natural justice in conducting the proceedings. But he was afforded an opportunity, which he did not choose. The authorities have disabled themselves to reaching by some consideration extending to the right of the time. The authorities have allowed themselves to be influenced by irrelevant or extraneous considerations. The conclusion on the very face of it is wholly arbitrary, capricious, and no reasonable person could have arrived at such a conclusion. But here there is only one option, either to accept or reject. The disciplinary authority had erroneously failed to admit the admissible and material evidence. The disciplinary authority had erroneously admitted inadmissible evidence which influenced the fact. The finding of fact is based on no evidence.
What will not the High Court cannot do, will not is in para 13. What I would like to submit to is Hindustan Aeronautics. It's a public employee. Statutorily, I followed due procedure. The submission is under this petition will not be there is no dispute regarding fairness of the
Sympathetically, is there any way out?
We have written to them, we have communicated.
How many years he has served? Nine years, huh?
2007 to 2016. About 9 years.
Just one point, just I wanted to clarify. It was not that he was regularly on the surface. Thereafter, he has remained unauthorized officer. That's not the case here. On 2 charges, he was suspended. Suspension was revoked when he went there to join on 10/2/2016.
He was
Transfer order was handed out. He would have gone there and joined Malad Seth. But he was insisting for the ID card. Because without ID, its stand is that even there.
How he can expect ID card? If the transfer is, of course, then the ID card would be issued there. He has to go to the other place, transfer order. ID card.
His higher ups, the department, making a request for reconsidering their decision. That also was not provided.
That would have done even after reporting to that at the transferred place. Reporting to duty, exercise you would have done. In all these cases, discipline plays the pivot.
ನಾನು ಇಲ್ಲೂ ಹೋಗಿಲ್ಲ ಅಲ್ಲೂ ಹೋಗಿಲ್ಲ ಈ ಸ್ಟಾರ್ಟಿಂಗ್ ಬಗ್ಗೆ ಏನು ಗೊತ್ತಿಲ್ಲ ನಾನು ಬಿಸಿ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಗೊತ್ತಿಲ್ಲ ಒಬ್ಬ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಏನು ಗೊತ್ತಿಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಕೇಳಿಲ್ಲ ಯಾವ ಸೈಡ್ ಇಲ್ಲ ಫೈರ್ ಮಾಡಿದ್ದು ನಾನು ಮಾಡಿದ್ದೆ ಫಸ್ಟ್ ಫೈರ್ ಮಾಡಿದ್ದೆ ಯಾವ ಪಬ್ಲಿಕ್ ಒಂದು ಫ್ಯಾಮಿಲಿ ಕನ್ಸಲ್ಟೇಷನ್ ಏನು ಕೇಳಿಲ್ಲ ನನ್ನ 2 days ಲಾಕ್ಡೌನ್ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡು ಏನು ಟ್ರೀಟ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಫ್ಯಾಮಿಲಿ ಕೂಡ ಅದೆಲ್ಲ ಒಂದು ಯೂನಿಯನ್ ಗೆದ್ದಿದ್ದೇನೆ ಅಂತ ಪವರ್ ತೋರಿಸ್ತಾರೆ ನಾವು ಮಾಡೋದು
ಯಾರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟರು ಹೋಗಿ ಅಫಿಷಿಯಲ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದವರು ಮಾಡಿದವರು ತಪ್ಪು ಕೊಟ್ಟಿಟ್ಟು ಅವರಿಗೆ ಡಿಸಿಪ್ಲಿನ್ ಡಿಸಿಪ್ಲಿನ್ ಏನು ಯಾವ್ದು ಓವರ್ಲೋಡ್ ಮಾಡಿದ್ದೀವಿ whether it can be posted to Yalanka based attest to that you can find out, not to this.
But what was suggested was without any languages,
apology also another apology.
Yes. It's a warning not to repeat it further. No, because of some other person, you should not suffer, Alba. Sometimes, no, it may be very difficult to bring. Yes, the inquiry officer may write. I said so. Huh?
none of these are coming out of records. But for me to even consider it. But in any event, I have communicated and they have refused not to accept. This expression, what you want to pass on, they are not ready to accept any. We tried. If I get say I will communicate, but they will not accept it.
No, the main basis for passing this order is that unauthorizedly absent for 10 days. Loss of lien. If at the gate, if they is not allowed to go inside, then how he will go inside?
Which works is not to enter a jail, you need an ID card.
Yes.
But that ID card is for specific divisions.
Yes.
There are about 89 divisions. If I'm not wrong. Not each division has their separate. Once only when he goes to Yelhanka base that next be issued ID card. Now from 11 to 2016, he has not gone there at all. To at least even take his ID card. Without the ID card, he can anyway not enter. The watchman will not allow.
Yes, even without the ID card, how he can enter?
But for that he has to report before the Yelhanka. In fact, he would have gone to Yelhanka base and taken the ID card. He kept on pressing for working here. In fact, he refused to take that letter of assignment. The watchman will not know these things.
No, how can we expect the watchman to know all these things?
That is why he is not letting them because
Yes, he is following his rules. He is writing not allowing any person who is not having the ID card. Yes.
he will always want to Yelhanka base and take the ID card except the appointment and then challenge him. But he did not go there at all from 11 to 2016 till about 14-3.
No, he says that he was there near the gate.
Not in Yelhanka, my lord. His statements are
Even at Yelhanka or on the main gate. No, when the transfer order was given to you, why you have not gone to the Telecast base?
He not stated anywhere that is going to Yelhanka. He stated that the main department is going. That is something that is new that is coming now in this. But I had no offense against it. The only thing is the procedure is correct.
Card ಬೇಕಂದ್ರೆ
ಟ್ರಾನ್ಸ್ಫರ್ ಸೈನ್ ಮಾಡಿದ್ರೆ
correct, you would have taken the transfer order ಅಲ್ಲ. ಎಲ್ಲಿ ಹೋದ್ರೆ ಏನಂತೆ, ಏನು ಯಲಹಂಕ ಏನು ಬೇರೆ ಊರಲ್ಲಿ ಇಲ್ವಲ್ಲ, ಬೆಂಗಳೂರಲ್ಲೇ ಇತ್ತಲ್ಲ. ಟ್ರಾನ್ಸ್ಫರ್ ಯಾರಿಗೆ ಎಲ್ಲಿಗೆ ಬೇಕಾದ್ರೂ ಮಾಡಿದಾಗ ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡು ಹೋಗೋದು ನಿಮ್ ಕರ್ತವ್ಯ ಅದು. ಎಸ್, ನೀವು ಇಲ್ಲ ನನ್ಗೆ ಬೇಕಾದಲ್ಲೇ ನೀವು ಟ್ರಾನ್ಸ್ಫರ್ ಕೊಡ್ಬೇಕು, ನಾನು ಅಲ್ಲಿ ಹೋಗಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಇಟ್ ಶೋಸ್ ಯುವರ್ ಎಸ್ 10 ಅಲ್ಲ 15 ಇರ್ಬೋದು ರೀ. ಇಟ್ ಈಸ್ ದ prerogative of the, for administrative reasons, for various reasons, the decision may be taken by the employer. ಎಲ್ಲ ನೀವು ಆಯ್ತು ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ಕೊಟ್ರೆ ನಾವು ತಗೊಂಡು ಹೋಗ್ತೀನಿ ಅಂತ ಹೋಗ್ತೀವಿ. ಅದು ಬಿಟ್ಟು ಅದು ಇಲ್ಲ ಇಲ್ಲೂ ಇಲ್ಲ ಅಂತ ನೀವು ಅವ್ರ ಮೇಲೆ ಕೂತ್ಕೊಂಡ್ರೆ other than this, there is no other via media. We cannot pass any orders now. Yes.
can always do it.
Allah court can do
The order
it.
does not do minor cases.
Allah
Court
court
can
can
direct
do
for
it.
reinstatement without bad cases. So 6 years he has lost. Yes, sir.
But we should same reason also, no?
Yes.
To arrive at a decision, simply we cannot direct. You reinstate them
Yes.
without back
That is
papers.
one of the synopsis I have two grounds. One is the principles of necessity.
What is the principles of natural
But
justice?
he has not only given reply. Unfortunately, they would have adjourned the proceedings for providing an evidence.
He stated that he does not have any evidence or document.
Then it's not required. What you have to follow, you have to follow. ಪೋಸ್ಟಲ್ಲಿ ನಾವು ಇವಾಗ ಒಂದು ಕೇಸ್ ಇದೆ ಅಂತ ಹೇಳಿ ನಾವು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿ ಎಲ್ಲ ಹೈಯರ್ ಅಥಾರಿಟೀಸ್ಗೆ ಎಲ್ಲ ನನ್ಗೆ ಗೊತ್ತು ಅಂತ ಹೇಳಿ ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಕಳಿಸಿ RPD ನಲ್ಲಿ ನಾನು ಪ್ರೂಫ್ ಇಟ್ಕೋತೀನಿ ಅಂತ ಮಾಡುದು ದಿಸ್ ಆರ್ ಆಲ್ ಪರ್ವರ್ಟೆಡ್ ಇಂಟೆಲಿಜೆನ್ಸ್. ಎಸ್ 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 ಕಳಿಸಿದೆ, ನನ್ನ ಹತ್ರ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಇದೆ. On the first day, who appeared before the committee stated that he does not need the assistance of a co-employee. Yes. And that he would defend himself on his own. The employee agreed to proceed with the inquiry. The employee was explained about the procedure of the departmental committee, which will be followed, and also about the right of defense. After reading the loss of lien notice and explaining the contents therein, the same was taken on record. Order here. Through your senior counsel, you can one more effort. No, just on humanitarian, hypothetically. Yes, now he has understood his mistake.
After last occasion, but I told that person to be present. I told him there will be an order from the court. You consider. But let's say if there is a court order, we will have to abide, but we cannot take that call. I don't want to make that. I tried my the letter was issued by my lord, my senior.
Where is that letter?
We get a letter in my office. I can get that.
You have to get updated. You have to get updated. It has come to office and there.
I can, in fact, I kept them present also.
He was here, huh? Chair was here. Sorry?
Direction to be present. But internally, we thought we could settle the matter. So we told him let the party person come and I will to get my HR name.
Records. Why you have not taken the assistance of a counsel before the CGIT also? Taken the assistance of a learned counsel before the CGIT as well as before this court. Why you wanted to argue this matter? ಇದು ಅಷ್ಟು ದುಡ್ಡಿಲ್ಲ. ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅಥಾರಿಟಿ ಪ್ರೊವೈಡ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಎಲ್ಲಿ ಕೊಡ್ತಾ ಇದ್ರಲ್ಲ, ಇದನ್ನ ಯಾಕೆ ನೀವು ತಗೊಂಡಿಲ್ಲ CGI ಇದು ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅಥಾರಿಟಿಯಿಂದ? ಅಲ್ಲ, ಇವ್ರಿಗೆ ಅಮಿಕಸ್ ಅಂತ ಇವ್ರನ್ನ ಎಂಗೇಜ್ ಮಾಡಿದ್ದು ಕೋರ್ಟಿಂದ, ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅಥಾರಿಟಿಯಿಂದ ಅಲ್ಲ. ಅಲ್ಲಿಗಿಲ್ಲ ರೀ, ಇನ್ನೇನು
Because the language was barrier before the worship related.
ನೀವು ನಿಮ್ಗೆ ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಕಡೆನು ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ಮುಂದೆನು ನನಗೆ ಎಲ್ಲ ಗೊತ್ತಿದೆ. ನನ್ಗೆ ಯಾರು ಬೇಡ, ಕೋ ಎಂಪ್ಲಾಯಿ ಬೇಡ, ಯಾರ ಅಸಿಸ್ಟೆನ್ಸ್ ಬೇಡ, ನನಗೆಲ್ಲ ಗೊತ್ತಿದೆ. Arrogance, sir. That is why we are putting all these questions to you. Again, before the CGIT, ನಿಮ್ಗೆ ಲೀಗಲ್ ಪಾಯಿಂಟ್ಸ್ ಎಲ್ಲಿ ಏನ್ ವೀಕ್ನೆಸ್ ಇದೆ, ಎಲ್ಲಿ ಲೂಪ್ ಹೋಲ್ಸ್ ಇದೆ, ಎಲ್ಲಿ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಾಗುತ್ತಾ? ಎಲ್ಲ ನನಗೆ ಗೊತ್ತಿದೆ. CGIT ಮುಂದೆನೂ ಬೇಡ, ಯಾರು ಅಡ್ವೊಕೇಟ್ ಬೇಡ, ನಾನ್ ಮಾಡ್ಕೋತೀನಿ. ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲೂ ನಾನ್ ಮಾಡ್ಕೋತೀನಿ. ಮತ್ತೆ ಹಾಗಲ್ಲ, ಹೀಗೆ ಆಗಿದ್ದು. ಹಾಗೆ ಆಗಿರೋದು. ಎಂಕ್ವೈರಿ ಆಫೀಸರ್ ಮುಂದೆ ಮಾಡ್ಕೋಬಹುದಾಗಿತ್ತಲ್ಲ, ನೀವ್ ಯಾಕೆ ಬೇಡ ಅಂತ ಹೇಳಿದ್ರಿ? ಐ ಡೋಂಟ್ ವಾಂಟ್ ಎನಿ ಕೋ ಎಂಪ್ಲಾಯಿ, ಐ ಡೋಂಟ್ ವಾಂಟ್ ಎನಿ ಅಸಿಸ್ಟೆನ್ಸ್ ಫ್ರಮ್ ಎನಿಬಡಿ. ಇದೆಯಲ್ಲ, ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಸರ್, ಇದೆ ಸರ್, ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ. ಇವಾಗ ಓದಿದ್ವಲ್ಲ ನಾವು. ಸರ್, ತಾವು 10 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ದೀರಿ. ಕೆಲಸ ಮಾಡಿದ್ಮೇಲೆ ತಮ್ಗೆ ಗೊತ್ತೇ ಇರ್ಬೇಕಲ್ಲ, 9 ವರ್ಷ ರೆಗ್ಯುಲರ್ ಎಂಪ್ಲಾಯಿ, 1 ವರ್ಷ ಟ್ರೈನಿಂಗ್ ಪೀರಿಯಡ್. ಯು ಆರ್ ನಾಟ್ ಎ ನ್ಯೂ ಎಂಟ್ರೆಂಟ್. ಲಾಸ್ ಆಫ್ ಲೀನ್ ಅಂದ್ರೆ ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ So during your suspension period also you are not paid with the subsistence allowance. So 19/8/2015 is the order of suspension pending inquiry. It was revoked on when 10/2/2016. 10/2/2016. ತಾರೀಕು ಮತ್ತೆ ಹೋಗ್ಲಿಲ್ಲ. Now where is that order dated 2/2/2016? Confirmation of punishment.
The relevant question is at page 101.
ಹೇಳ್ತಾರೆ, though the proposed punishment would commensurate the misconduct, considering the gravity of misconduct, a lenient view is taken in the matter, and I hereby impose the punishment of stoppage of 2 annual increments without cumulative effect, as per clause 27(a)(3) of the certified standing orders of the company. Further, the order of suspension issued dated is revoked, and you are hereby permitted to join duty with immediate effect. The period of your suspension from 19/8/2015 to 2/2016 shall be deemed to have been on duty during the period of suspension, and you shall be entitled to the same wages as you would have received if you are not being placed under suspension. This order is dated 2/2/2016.
The thing is that period of suspension is said to have
Treated as duty. That is well considered order. After the
This order is communicated to him and he joins on 10 to work. Transfer order ಎಲ್ಲ ಇವ್ರು ನಾನು ಹೈಯರ್ ಅಪ್ ಮಾತಾಡ್ತೀನಿ ರಿವೋಕೇಶನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ ಐ ಡಿ ಕಾರ್ಡ್ ಕೊಡಿ ಒಳಗಡೆ ಬಿಡಿ ಈಗ ಹೋದ ರಿಪೋರ್ಟ್ ಅಂತ ಹೇಳ್ತಾರೆ ವ್ಯಾಲ್ಯೂ ಹೋಗೋದಾಗ ಇಲ್ಲಿ
ನೀವು ಒಳಗಡೆ ಹೋಗಿದ್ರೆ ಅಸೈನ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕೊಡ್ತಾ ಇದ್ರಲ್ಲ ನಿಮ್ಗೆ. Are you ready to go to Yelahanka now? Yelahanka go ready ಇದೀರಾ? GMO ಬೇಡ, ಐದು ಕಾರ್ಡು ಬೇಡ. Are you ready to go to Yelahanka now? ಚೌಕಾಸ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರಾ ನಿಮ್ಗೆ? ಅದೇ ಗೊತ್ತಿಲ್ಲ ನಿಮ್ಗೆ, ಏನು ಗೊತ್ತಿಲ್ಲ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಅದಕ್ಕೆ ನೀವು ಅಡ್ವೊಕೇಟ್ ನ ಎಂಗೇಜ್ ಮಾಡ್ಕೋಬೇಕಾಗಿತ್ತು. ಎಲ್ಲಾರು ಹೀಗೆ ಹೇಳೋದು.
wages are paid for the entire period before it is due to be.
So 2/2/2016 is a well considered order. It is your misconduct which has made you to come to this level. So this is not a forum for you to take advice here. Our time, relevant time, you have to take the advice, not at this stage. Past records andre ಏನು past records?
Yes, right.
Before that, that charge sheet that I showed that my initial R1 earlier
that is see, that is
I think that again is taking day pass and for medical purposes to go to HL hospital. You said he doesn't go there, he goes to some other place. It doesn't matter very well, but he took a day pass for going for HL hospital, but he did not go to hospital.
But he has gone to the police station. He has gone to the police station.
The reason for availing the day pass was going to HL hospital. They said that he is never reported.
But he is not, he never reported to HL hospital, but he reported to the, he has gone to the HL police station to lodge a complaint. I can't reconsider it. We'll remand the matter back to the authorities to reconsider it.
From the management level, they will not be. But in fact, to even consider remand record, there has to be some reason. My only thing is he's not producing it. So either we will have the question of natural justice, but your lordship could direct the matter to be decided. That is also not in dispute because there is already on record document saying that due process has been followed. He is given a process. The next question is quantum of punishment. There again, there is no question because it is not a minor or major manifestation. But nothing else is there to be adjudicated by the tribunal. What cannot be interfered. That is not.
Let us see that loss of lien. What is the
Standing
relevant standing order? That
82. That's all.
Carry order itself there. This will give the order CH-3.
82. 82 says 10 days or more, but the notice for loss of lien was issued almost 1 month later because it did not come for 1 month. Plus 2, if a workman remains absent for more than 10 days, and or absence is beyond the period of or subsequently extended, he shall lose his lien on his appointment unless he returns within 10 days of expiry of the notice of appointment. It explains to the satisfactory of the management the reasons for his inability to return on the expiry of the notice. If the explanation of the workman is found not satisfactory, or the workman does not submit an explanation before the specified, in order to afford one more opportunity to
now, whether the matter was referred to the departmental inquiry.
I don't know what to do the evidence and cross-examination that we conducted of the management.
That is departmental inquiry. Think of one person. Here, one person was based on the findings of the departmental inquiry. The manager shall pass.
Only thing is whether the issuance of loss of lien notice was legal or illegal is a question.
So even if we demand also the same order, futile exercise. It could be a futile exercise. Whether this comes under the acts of misconduct here, acts of no, in clause 25, it is specified what are the acts of misconduct.
There is a specifically provision in the standing matters for major and minor penalties. But for loss of lien, there is also a separate clause under which no proceedings are initiated. So it works like this. If he does not submit an explanation to the notice of loss of lien, he automatically uses lien as notice appointment. I did not even initiate departmental inquiry. But if he gives an explanation and it is found unsatisfactory, inquiry proceedings should be initiated. Now in the inquiry, the result is only two. Either the loss of lien notice is legal or it should be taken back.
So it is not for the act of misconduct.
It is a separate statutory provision that is
This is loss of lien, termination of employment.
Yes. In fact, if he had not submitted explanation, he would have automatically lost the lien on appointment. That is what the first portion of the clause says. Second line, he shall lose his lien on his appointment unless he returns within 10 days and explains to the satisfaction. So if he had not submitted the explanation, he would have automatically lost.
So departmental inquiry was held.
Because he submitted explanation,
So committee was constituted.
and he participated, he cross-examined management witness, did not choose to be evidence. But order was passed, confirming the loss of lien. after relying on the decision of the Supreme Court, labor court has confirmed the order.
It is ನಾವು ಹೇಳ್ತಾ ಇದೀವಲ್ಲ, ಇಟ್ಸ್ ಅ ಪ್ರಿರೋಗೇಟಿವ್ ಫ್ರಮ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್. ನಿಮ್ಮ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ನ ಕೇಳ್ಬಿಟ್ಟು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬೇಕು ಅಂತ ಇಲ್ಲ. ಎಸ್, ಲಾಸ್ ಆಫ್ ಮೀನ್ಗೂ ಕೂಡ ನಿಮ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಕೇಳ್ಬಿಟ್ಟು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬೇಕು ಅಂತ ಇದೆಯಾ? ನಿಮಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ಕೊಟ್ರು, ನೀವು ಬರ್ಲಿಲ್ಲ 10 days, ಲಾಸ್ ಆಫ್ ಲೀನ್ ಆಯ್ತು. ಲಾಸ್ ಆಫ್ ಲೀನ್ಗೆ ನೋಟಿಸ್ ಕೊಟ್ರೆ ನೀವು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಟ್ರು, ಎಕ್ಸ್ಪ್ಲನೇಷನ್ಗೆ ದೇ ಆರ್ ನಾಟ್ ಸ್ಯಾಟಿಸ್ಫೈಡ್. ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ರು. ಅಸೈನ್ಮೆಂಟ್ ಮೆಮೊ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ 10-2 ನಲ್ಲಿ. ಯಾವ್ದಾದ್ರು ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಏನಾದ್ರು ಇದೆಯಾ ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ? Loss of lien. No, this now it is on the loss of lien. Now, it is on the loss of lien. Because that loss of lien
should be understood as a misconduct only. Because independent chapter is provided for that standing order. That does not mean that they are required to exercise the discretion. Standing order cannot permit us for them to impose lesser punishment. But always this honorable court has the power.
this court has got power, but do you have any judgments?
Standing order.
No, do you have any judgments in the case of loss of lien? This court interfered. This court interfering in the case of loss of lien?
These are very clear. So when that I cited and directly applicable.
These statements are referred by the CH-3.
Supreme Court says that there is no question of
Then it's very difficult for us to.
My difficulty is also it is not there. What is not there in the department inquiry. For external factors, I cannot argue. That is one difficulty. He says 100 facts.
Tried at least help ಮಾಡೋಣ sympathetically because but our hands are also tight. In ಮಾಡಕ್ಕಾಗಲ್ಲ. If any, because we should not lay down any law contrary to the well-established principles, divorcing from the settled principles of law. Sorry, sir. We tried our best. ಏನಾದ್ರು ಮಾಡಕ್ಕಾಗುತ್ತಾ ಅಂತ. Repetition stands dismissed. Amicus 10,000. ಅಲ್ಲ 10,000 ಏನೋ ಅಲ್ಲ ಅಲ್ಲ ನಿಮಗೆ ಬೇಡದೇ ಇರ್ಬೋದು ಲೆಟ್ ಇಟ್ ಬಿ ದೇರ್ ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಬೇಕಾದ್ರೆ ಹಾಕೊಳ್ಳಿ. ವಿ ಅಪ್ರಿಶಿಯೇಟ್ ದಿ ಅಸಿಸ್ಟೆನ್ಸ್ ಗಿವನ್ ಬೈ ದ ಅಮಿಕಸ್ ಕ್ಯೂರಿ. 10,000 ಫಿಕ್ಸ್ ಮಾಡ್ತೀವಿ. ಬೇಕಾದ್ರೆ ನೀವು ಆ ಪಿಟಿಷನರ್ಗೆ ಕೊಡೋದಿದ್ರೆ ಕೊಡಿ, ನಿಮಗೆ ಬೇಡ ಅಂದ್ರೆ. other matters, rest of the matters by next week.